trying to accommodate all members. So that
This is a fresh matters.
the lawyers who are starting not as senior as you, because you have the stranglehold over the. When I started, I was told so my practice will be as good as my Mori is. I'm an advocate's club. So how to take care of that? Who enters the profession today, he can't afford a. I mean, the kind of payment structure here is you can't afford a lawyer. I'm sorry, you can't afford an advocate's clerk. A lawyer cannot afford an advocate's clerk.
No.
That is on philosophy. Let us see.
Stage 1, 3 to 6,
Yes, next please.
stage 2,
Page 2,
7
item number
13,
9, minor.
9.
Kindly adjourn this matter to next week.
Your name, sir?
My name is Vivek Ranjan Behera.
Eh?
My name is Vivek Ranjan Behera.
Vivek Ranjan Bhai.
On behalf of Mr. Siddharth Das.
Have you gone through the brief?
No, minor.
Seen the order just in front of you?
Yes, my lord. I have seen already the order.
Good, good. Always before mentioning, look at the
Yes,
brief,
yes, ma'am.
cause list, go through the order.
Yes, ma'am.
What the questions court will ask.
Our order lordship was directed to
Item 9, the matter was heard at length
I am,
on 23/2/2026.
my lord, I am serial number 1.
Field number 1 you should not mention, sir. It has been listed for a purpose. So you have to have courtesy for the court and your colleagues. They are mentioning why every matter should not be mentioned there.
Sir,
Only. Just wait. If you have any difficulty, if you have any time. And Mr. Vivek Ranjan Behera on behalf of Siddhartha Das for the petitioner. The matter was heard at length on 23/2/2026. Stop. The Learned Counsel for the petitioner had adjournment to answer the issues discussed. Deliberated. Stop. Today, the matter being in the list is mentioned by the Learned Counsel mentioned on behalf of the Learned Counsel for the petitioner to be adjourned. Stop. Para. To grant further opportunity, list in the week commencing 6/4 fresh ହେଲା ସେମିତି ରଖିବେ fresh orders ତାପରେ after notice. Yes. କାହିଁକି ମେନସନ କରୁଛନ୍ତି କଣ ପାଇଁ ଆସିଛି ଆଗ ଦେଖିବେ. Then 2015 ମ୍ୟାଟର ଆପଣ 11 ବର୍ଷ ପରେ ଆର୍ଜନ କରୁଛନ୍ତି. ସେଟା ନ ଦେଖିଲେ ଅର୍ଡରଟା ଦେଖନ୍ତୁ ଯଦି if I start dictating orders then you cannot wait, Mr. Polai.
This matter has nothing to adjudicate, my lord. This is only for academic purpose. से जो registration को challenge करते हैं question.
Right.
In the meantime, 3 thorough renewation.
Bas.
That your lordship has also.
So I have observed that order.
Yes.
Thanks, because although I have not opened, I could remember.
Yes.
Mr. Polai, you are for Mr. S. Polai on behalf of D.R. Mahapatra. After 11 years of presentation of the writ application on 4/8/2015, after more than 10 years, case they are much older than the next generation children also. After 11 years of the matter, after almost 11 years of the matter having been presented before this court, adjournment is sought for at the beginning of the proceeding by mentioning para.
Order dated 9/2.
The matter was earlier taken up after almost 10 years on 15/1/2026. After more than 10 years, after on 15/1/2026 and 9/2/2026. On 9/2/2026, the Learned Counsel for the petitioner as well as the Learned Counsel for the state, Learned AGA for the state, Mr. Lenka, were heard at some length
Then Mr. Mahanti was there.
Mr. P.K. Mahanti.
P.K.
Okay, Mr. The Learned AC. It is Mr. Mahanti, P.K. Mahanti. Some length and orders were passed. Apparently, no reason can be decided, no reason can be attributed for adjourning the matter. Stop. However, to grant further opportunity, the matter shall be listed for orders
13
in the week commencing 6/4. ଆଉ ସେ ଆସିବନି ବି ସିଏ ଆପଣ ଯୋଉ ଅର୍ଡର ସିଏ ଆସି ଆଉ ଦେଖା ବି କରିବନି ମ୍ୟାଟେରିଆଲ ଇନଷ୍ଟ୍ରକ୍ସନ ଆଉ କଣ ହବ ଦିସ୍ ୱିଲ୍ ନଟ୍ ମ୍ୟାଟେରିଆଲାଇଜ ୟେସ୍ ନେକ୍ସଟ ୟେସ୍ ପ୍ଲିଜ
page 3, 14 to 19.
Item 14, my lord.
ଓକେ
Maybe adjourned to after 2 weeks. We are awaiting for instructions.
ये भी ऑर्डर्स पे ଆସିଛି କଣ ପାଇଁ ଆସିଛି योर नेम सर
S. Dheer,
एस धीर ऑन बिहाफ ऑफ
Prasanna Kumar Mishra.
मिस्टर एस डॉट धीर फॉर प्रसन्न कुमार मिश्रा फॉर द पिटिशन ऑफ 14 डेट करंतु
We commence in 13.
आई विल डिक्टेट द ऑर्डर
Lakshmi, see the order dated 3rd February 2026. Only today it has come for deletion of opposite action number 1. The IA they have filed.
though the matter is listed for orders the adjournment is sought for at the beginning of the proceeding on behalf of the learned counsel for the petitioner on ground of personal difficulty 14 is assigned to you Mr. Lenka
No, it is Mr. P.K. Sahoo.
14
Yes, this is an action to make. Earlier order was the P.K. Sahoo.
नहीं अजी का असाइनमेंट है अपीयरेंस का जो ऑर्डर पास कर
My
मिस्टर डीएन लेंका फॉर द एजी मिस्टर एस डी फॉर ऑन बिहाफ ऑफ पीके मिश्रा मिस्टर डीएन लेंका एजी आप लिखिए दो listed for orders adjournment is sought for by the learned counsel for the on behalf of the petitioner for the learned counsel for the petitioner the learned AG refers to the order dated 3/2/2026 for consideration of the IA 13430/2025 so to grant further opportunity to the petitioner list on 13/4/2026
Page 4,
No, item
20 to 26.
item 24, my lord. 4 weeks time to file rejoinder. Petition is not well. You are also directed to file rejoinder. So
कोड कितना नंबर आइटम कुछ
item 24, my lord.
योर नेम सर
L Jana, my lord.
पात्र मिस्टर पात्र को 24 रे
Mr. I have taken concern of Mr.
24 मिस्टर
I have taken concern.
कार असाइनमेंट मिस्टर लेंका ଆପଣଙ୍କ ଆସାଇନମେଣ୍ଟ ଯୋଉ ଥିବ ମିଷ୍ଟର ବେହେରା ତ ପ୍ରଭୁ
L Jana.
କେବେ ଡେଟ୍ କରୁଛନ୍ତି 24ଟା
We commence in today charge.
I'll dictate the order when the matter reaches.
That's item 21.
Yes,
Pray for adjournment. On behalf of Amita Tripathi, I have taken consent from the other side.
many times your consent is no consent. They say that no consent have been given. Either of you have to be true. Not in maybe, it may not be in your case. 21 टा simply date कर दियंतु. Order किसी पास.
We commence in today charge.
Okay.
Madam, your name is?
Saubhagya Lakshmi Patnaik, Lords.
इसमें ऐसी बंद होती है तो. हाँ. the constitutional.
That's not in the list. I file a memo.
Promoter ଦିଅନ୍ତୁ
Yes, sir.
ଯୋଉ ଯଦି ଲାଷ୍ଟ ଆଗରୁ ଅର୍ଡର ହେଇଥିବ ତାହେଲେ ସେଟା ବି ଲେଖି ଦଉଥିବେ so that it can be tracked. It still we have, I think we have to go for a longer, permanent solution is, better solution is not permanent, computerized mentioning. So that this matter is traced out.
The date was fixed, but
The date, because any kind of any holiday or absence relates in piling up of the matter.
the change in
And
roster.
the roster also is that, so,
Yes,
so
that
someone,
was-
every day there has to be some hearing matters.
Yes.
And hearing matters are taken up in fresh admission orders also because of the urgency. So if you mention that earlier on, so the memo was given, just write that line so that it can be traced out.
Hence, much obliged.
And system should be transparent actually.
Page 5.
ଆପଣ orders की admission कौन लिखिଛନ୍ତି ତ? After notice
Yes.
hearing ଯାହା ସେଟା ଲେଖି ଦେଇଥିବେ. Yes, page 5. Yes, जल्दी quick नाହାନ୍ତି.
27 to 31. Page 6. 32 to 40.
38 sir, Sumanti.
For its time to file agenda.
Mr. Rai, you are Mr. Tripathi,
Yes, ma'am.
ND Tripathi.
Yes, ma'am.
ND full form is
Nigam Darsi.
Nigamanassi. डेट कर दियो तो सिंपल डेट आज पोस्टिंग कर दो
Vacancy 27.
Item 14.
36 चल
It's item 39. I beg to
just one second just
Much-
wait
much
you get number
Much obliged.
Mr. Tripathi is saying something 40
40. The instruction has not come.
okay 40 रो डेट करंतु
Vacancy 27.
Obliged.
yes madam 39
Item 39, the state is yet to file a counter. I believe my learned friend will be taking some time
yes
to
nothing
For which time may be allowed to file count?
simple posting कर दियो
Milots. I also appear
Okay,
Milots
sir.
along with Mr. Purva, Mr. Purva Milots.
week commencing 27 तारिख होचंती
Milots, the interim orders to continue.
no I am not touching the interim order as such it is there interim order goes continues
That is there.
It's like any interim order till next date. Usually,
If
I don't pass, but they are typing that as interim next date. So I don't pass any orders which has to be mentioned for listing, and that creates further complication in listing.
No,
Yes.
nothing on that.
So
Much
you are
obliged.
free to mention that so that I can know.
Milots. Much obliged, Milots.
Yes, sir.
Item 33.
Yes.
Taken
Mr.
up
Bhuya,
after 2 weeks, man. Absolutely.
Mr. Jalli ଆସୁନାହାନ୍ତି
No.
ସେ କଣ ଜଲ୍ଦି ଯୋଉ Mr. Tripathi is smiling.
Yeah.
No, I mean, Mr. Jalli has been made immortal. He is fortunate to have, let us call him Jalli, not Jalli. I had a friend actually, long back in my primary school. Sibasankar Jalli was a good student. His brother was in railways or some central government service. Yes. Date कल कि अपन कहले मिस्टर
Vacancy 40.
24 वीक कोछ
Obliged.
ଆପଣ 26 ସେଇ ଆପଣଙ୍କର ସେଇ ପ୍ରୋବ୍ଲେମ 26 ଯୋଉ ମସିହାର କେସ୍ କୁ ରଖିଲେ 27 4 ଆଚ୍ଛା 25 ରୁ 20 4 ଠିକ ଅଛି ଠିକ କରୁଛନ୍ତି yes
Item 1.
yes ma'am yes sir ଆପଣ you are Mr. Behra
No, on behalf of
Nada sir
Badri Narayana Rai.
Mr. Badri Narayana Rai for on behalf of PK Behra -1 for the appellant yes what do you want sir refer ହେଇ ପାରିବ କି ନାହିଁ
I have submitted exemption of court fee because the petitioner is a scheduled caste person and notification has been annexed in
ସେଟା ତ ସେଟା ଷ୍ଟାମ୍ପ ରିପୋର୍ଟିଂ ସେଟା ଜୁଡିସିଆଲ ଅର୍ଡରରେ ହୁଏନି स्टाम्प रिपोर्टिंग रे आपण ऑर्डर कले जाकी हौ और आपनकर मेडिएशन में कौन इंस्ट्रक्शन अछि कोंतु
The record, trial court record we called for.
they already sir already stamp the court fee has been 187 तो डिस्पोज ऑफ हेगला फिर आथरे कोन लिस्ट है
That's मैं
को भी
Please,
इससे कौन करछन किछि देखो ना
Already allowed, my lord.
I'm just they have mentioned it. Mr. appearance लिखले again Badri Narayan
right.
Mr. Badri Narayan Ray Arivai on behalf of Vijay Kumar Behra for the petitioner. Mr. Petitioners plural हम बहुत जन अछंती ना कित जन petitioner ना जन petitioner singular आपण रिक्विजिशनिंग अथॉरिटी किए तक तो पार्टी करनांती पैसा जी आपण को देबे किए से किए पैसा देबे who will give you the money compensation from whom you will receive the compensation
Special land acquisition officer.
he doesn't acquire any land even if suppose the land acquisition officer wants an office usually it's the collector one revenue the deputy collector or the ADM is the land acquisition collector. Suppose he wants to acquire land, then he has to give a requisition. Suppose he wants to have an office, right besides in CDA. Kotak LAO wants an office. So he'll be requisitioning. In your case, for the land was acquired for what? Then always go through the brief.
Instruction.
Instruction इधर कितने होगा इतनी इंस्ट्रक्शन कौन हो कौन जितने फाइल टा रिसीव क्वेश्चन सो एवरीथिंग इज सेटल्ड दिस इज अरेंजेस आउट ऑफ द रेफरेंस अंडर सेक्शन 18 ऑफ द लैंड एक्विजिशन एक्ट इतने कौन इंस्ट्रक्शन कौन नहीं हो अपन तो पार्टी करंतु जे आप जहां को पैसा मागिबे यूपी आवास एंड विकास निगम देयर इज अ कॉन्स्टिट्यूशन बेस्ड डिसीजन फॉलोड बाय 2-3 जजमेंट्स ऑफ दिस कोर्ट that the requisitioning authority should be made party because he will give the money. Now suppose the here is the irrigation department. They have to pay the money, and they have not been made a party. The office the matter has been listed. Notice जाइनी इतरे
Notice has gone.
तापरे कौन है स्टेटस ऑफ एवरीडे गोटे सेम जिनस आपण मानकर Mr. P.K. Bhanti, ASC for OP number 1, respondent 1, R1. All right. The matter is listed under the heading for referral to the Special Mediation Drive 2.0 Mediation for the Nation. So, para. Though the matter is an appeal, the office note put up by the registry does not indicate in the cause list how many of the respondents have been served, who are the lauded counsel appearing for the respondents, what is the status of each of the parties as far as sufficiency of notice is concerned. The matter shall be placed before the registrar judicial to instruct the concerned superintendent as well as the ASO to be meticulous in presenting the brief before the court. Stop. Then para. IA 187 of 2022, though disposed of by order dated order number 1 dated 22/12/22 has been again listed. There has been again listed, indicated in the comma, indicated in the cause list. Stop. In view of the order by the coordinate bench disposing of IA number 187 of 2022, the IA shall be treated to be disposed of. Stop. The matter shall be listed under the same heading on fresh ଯେମିତି ଅଛି ସେମିତି ଆସିବ 6/4 in the week commencing 6/4/2026. Registry shall do the needful. The Lord AC shall obtain the out ଲେଖନ୍ତୁ 6/4 ପୂର୍ବରୁ ଲେଖି Matrimonial district ପୂର୍ବରୁ ଲେଖିବେ. In view of the judgment rendered by the Constitution Bench in EP Awas and EP Awas एवं विकास निगम, EP Awas एवं विकास निगम, the project proponent oblique requisitioning authority on whose behalf the land has been acquired should be heard. From the perusal of the judgment dated 19/7/2022 in LAR 71 of 2007 oblique C number 2 of 2020 लिखिए भूल वाला page 9, which was rendered by the Lord Civil Judge Senior, the Civil Judge Nuapada, District Nuapada, indicates that in the reference, the project proponent, that is Government of Orissa, Irrigation Department, Water Resources Department, was not made a party. Stop. The lauded trial court, the lauded referral court, Act, 1894, for reasons best known, has not issued direction for implementing the project proponent oblique requisitioning authority. Para. The allotted counsel for the appellant submits that since the special land acquisition officer Lord Indra irrigation project Khariar is made a party, the requisitioning authority need not be made a party. The allotted additional standing counsel shall also obtain instruction in response to the said submission. FSA. The special LAO is a statutory authority defined under the LA Act 1894, whose role is adjudicatory in nature, as he considers and disburses the land acquisition compensation to the land losers from the amount deposited by the project proponent. Stop. Para. तापर ये लिस्ट से रहिला तଳ ଉପର करते yes.
Item 2,
Obliged. Level that will be referred to the mediation center.
Have you made the party mediation? The party should be there to be mediating.
Party, my lord, the land acquisition officer has given notice to us to receive compensation. He has received.
If you start blabbering some things, I can't waste time like this.
Sorry.
The Lord of Council did not say anything, and you say something. I could not understand what you are saying.
Sorry.
What is the question, sir? I am equally more sorry than you. What is the question to you, sir?
I have not made party.
No, sir, that I never asked you. Sir, whether for enhancement, did you the person who will pay the money has been made a party?
My lord, the land action has taken all the charges. He has sent notice. He has given money. We have received money from him, and he will.
Sir, you understand Odia or English or Hindi or
Odia, English, Odia.
Role of land acquisition officer? I am not asking.
No.
Does he pay the money from his pocket or he gets the money deposited by somebody?
No, the executive engineer, the requisitioning officer should give money to the land
Exactly.
action
So that
officer.
have you read DP officer Vikas Nigam, you are a lawyer?
Well,
You are a lawyer advocate, sir.
yes.
You have to read constitution being decision. Or the LO will read. Whenever there is a issue of giving money, the person who pays has to be heard. Then suppose now I ask you, address me on the functions of land LAO. What would be your answer?
LAO is taking charge of all this.
So then how two answers are similar? When I ask you that what is the function of LAO, you say the same thing you are saying, whether you have
Distribute compensation.
Exactly, sir. So how the two answers are one answer for all questions? Mantra to no hai. Function of LAO आपन को पचारले मु जानिने आपन मते बुझेले तापर जतो पचारली जे आपनकर लैंड जे प्रोजेक्ट पैसा जे देबे ताको पार्टी करनांते सेम आंसर सब्स्टिट्यूट का हिनांती से चली गले सेम आंसर एमती हेले केमती हबो
My lord,
Mr. What's your name, sir?
SC Mahanti.
So Mahanti, we are being watched. It is a live proceeding.
Yes.
When I ask you that whether you have made the project proponent a party, you are explaining me what is the function of the LAO receives money, issues notice, distributes money,
And taken possession.
so then that's the only answer to be given in a.
My lord, it is his duty to require money from the development, water system.
His duty, which provision he will require money?
Because in section.
Sir, you are not playing with the gallery. You must understand. If there is a provision, then you have to refer to the constitution bench. Why the constitution bench has said that the project proponent has to be heard.
Provision is only land.
The problem is that lack of reading is fine.
No, my lord.
Then you don't prepare the case. Come to court and give a speech. Which provision?
My lord.
Sir, it can't be a smiling answer.
No.
Under which provision of 1894 LA Act?
Under section 18, LAO land action officer should.
Sir, you said that he collects money and gives it. Which provision I am asking?
He proceeding is done by land action officer.
Sir, bluffing is a good act, but you have to now. Bluffing to a dumb person and bluffing to in a court are different things. Which section that the land acquisition officer will collect money?
Means collection.
After determination of the compensation, it is deposited by the project proponent.
Before land action officer.
Not before. Who deposits? Again, you are changing the question.
Engineer deposit.
Exactly. So, have you made him a party?
It is the land action officer. He should.
Sir, this is a struggle. I'll record and dismiss.
No. Sorry.
I can also read a slide.
Not party.
No. I have to record and dismiss it.
No, my lord, I am at park. I'll make.
I know, my lord. You can say land acquisition. I'll record your submission.
Resources department.
Sir, I'll record that land acquisition officer. Has been listed.
Land development, water.
Sir, have you made a party in the section 18?
Yes.
Section 18, have you made a party?
What?
In the reference under section 18, was the executive engineer made a party?
No.
Then I'll record your submission.
I'll make party.
I don't know, sir. I can't, I'm not running with a begging bowl. This is operation of law. If you do not take care of the interest of your client, only God also cannot help it.
I'll add him.
Much less the court.
I'll add him.
This question will haunt till Supreme Court.
I'll add him.
Mr. Sudhir Chandra Mahanti for the appellant. You take your seat, I'll dictate order.
No, I will add him party.
I'm not dismissing, sir. I'm not dismissing, but I'll record your submission.
Oh.
You are having funny time, smiling and giving strange answers. My duty that I have to scrupulously record your submissions. I'll record it and I'll grant you time. The matter is listed before so and so. Sudhir Chandra Mahanti for the petitioner, Mr. Being casual, sir, in legal profession doesn't help. That is the basic thing I have been told.
Sorry.
And no,
I apologize.
sir, sorry, sir. I am very sorry, sir. I have to tell you this. I may be a little bit more experienced than you, but that's a different thing.
Yes. Apologize.
Looking at you, I think that I am older. But that doesn't mean that. Suppose I take you seriously, I pass that wrong order. The land division officer collects money.
I will suffer. No college.
No. Just imagine the situation. I take your, because I will also not read any decision or anything. I'll not read the section. I'll record that. That under the provisions of 1894 Act, land acquisition officer collects money and distributes.
Not collects. It is his
Sir, you use that language, sir.
proceeding is his duty.
Sir, you use that language, sir. Sir, what you are saying is unthinkable. That officer will get money from everyone. Sir, that money is different money. That money never takes care. That is much less can be adjudicated. Suppose enhanced compensation, the officer distributes you, and he does something with the money also. So that is a different concept altogether. So P.K. Mahanti AC for the response.
My lord, SC Mahanti.
ସମସ୍ତେ ଏସି ହେଇପାରିବେ ନାହିଁ ଏସି ହେବେ ପିକେ ହେବେ there are so many Mahantis ଆପଣ ସମସ୍ତଙ୍କୁ ଏସି କରିଦେଲେ କେମିତି ହବ
Sudhir Chandra.
କଣ ପଢନ୍ତୁ ଆରେ ପଢନ୍ତୁ ସାର୍ ଶୁଣନ୍ତୁ ଆପଣ ସାର୍ ଶୁଣୁନାହାନ୍ତି କଣ କରିବା ସାର୍ ଆଜି ପୁରା ଫୁଲ ଫର୍ମରେ ଅଛନ୍ତି ଆପଣ କାହିଁ ପେନ୍ ଦେଖଉଛନ୍ତି ଦିସ୍ ଇଜ ବ୍ୟାଡ୍ ମ୍ୟାନର୍ସ କାଲି ଜଣଙ୍କୁ ଶିଖେଇଲି ସେମିତି କଥାବାର୍ତ୍ତା କରିବେନି ବୋଲି ଆପଣଙ୍କୁ ହେଲା ପଢିବା ପାଇଁ ପଢିବେ ତାଙ୍କ ନାଁଟା ପଢିବେ କଣ ଲେଖା ହେଇଛି ସେ ସୁଧୀର ଚନ୍ଦ୍ର ମହାନ୍ତି କହୁଛନ୍ତି ଆପଣଙ୍କ ନା ଆଉ ଥରେ ଡାକିବାକୁ ପଡିବ ମିଷ୍ଟର ସୁଧୀର ଚନ୍ଦ୍ର ମହାନ୍ତି ଫର ଦ ଆପେଲେଣ୍ଟ ମିଷ୍ଟର ପ୍ରେମ କୁମାର ମହାନ୍ତି ଫର ଦ ରେସ୍ପଣ୍ଡେଣ୍ଟ Notices were issued by the coordinate bench. After acceptance of the deficit code P by order dated 19/4/2023. Notices जो लिख लेनी जरा काटी दो. After acceptance of the code deficit code P as directed by order dated 19/4/2023, the appeal was admitted. But thereafter, it has been listed under the heading so and so, so and so. The Lord Counsel for the appellant was had at some length. The project proponent, that is the Department of Water Resources, has not been made a party in the appeal, nor was a party before the Senior Civil Judge Kendrapada in the proceeding initiated under in the proceeding arising out of the reference under section 18 of the Land Acquisition Act 1984 or 1894 also 1894. In view of the constitution bench, the decision of the Honorable Apex Court rendered by the Constitution Bench, UP Awas and Vikas Nigam, deciding answering the question of law that the project proponent, oblique requisitioning authority, has to be heard for in a proceeding under section 18 of the LA Act 1894 for enhancement of the compensation to be granted to the land losers. The learned counsel for the petitioner was asked whether the project proponent, that is the Department of Water Resources, was made a party in the present proceeding before the referral court. Stop. Or in the appeal. Stop. Semicolon, colon per comma per bindu, semicolon. It is submitted by the learned counsel for the appellant that the land acquisition officer receives money from the project proponent. He does the all statutory work, allocates and distributes the money, compensation amount to the land losers. Therefore, making the land acquisition officer is enough to represent the project proponent. In considered opinion of this court, after the authoritative pronouncement by the Honorable Apex Court, in UP Honorable Apex Court Constitution Bench, in UP Abbas এবং Vikas Nigam, which has been followed by this court in so and so, data decision. The contention is the contention raised by the learned counsel for the appellant is not correct. Stuff. On being asked of Para, he also fairly concedes that the executive engineer Manadi Chitrotpala. Manadi Chitrotpala irrigation project.
Island irrigation.
Island irrigation.
MCIA.
Manadi Chitrotpala Island irrigation project had deposited the money before the special LAO. Stop. As per the statutory scheme of the Land Acquisition Act, the special LAO does not deposit the money, nor he is authorized to deposit any money. Rather, he is the statutory authority as defined in the statute for disbursement of the compensation deposited by the project proponent oblique requisitioning authority. Stop. You make him party, it has to be remanded. Because for your client, if you look at your clients, this court is the Supreme Court.
In other case, he is made party.
So the difficulty is that he was not had in 18. I do not know who has done this. You have permanently damaged the case of the petitioners, the appellants. Without hearing the state, the order has been passed by it's a mistake by the trial court. It is a blunder, in fact, because suppose in a criminal trial, the public prosecutor will not be heard.
Public prosecutor is appearing for all.
Full form criminal trial re public prosecutor hearing karibeni is not recorded. Trial ta kon hobo? Gala se trial. ଆପଣଙ୍କର ଯିଏ ପ୍ରୋଜେକ୍ଟ ଅପୋନେଣ୍ଟ ଯିଏ ପଇସା ଦେଲେ ଆପଣ ଯାହାଠୁ ନେଇଛନ୍ତି ବି ପଇସା ତାକୁ ପାର୍ଟି କରିନାହାନ୍ତି। ଇନ୍ ଦ ସ୍ପେସିୟସ୍ ଆର୍ଗୁମେଣ୍ଟ ଦ୍ୟାଟ୍ ଆପଣଙ୍କୁ ଯୋଉ ଅଫିସରୁ ମିଳିଲା ସେ ଅଫିସର ପଇସା ଆପଣ ସେ ଲୋକଟାକୁ କରିଛନ୍ତି। ଆଉ ଟ୍ରାଏଲରେ ତାହେଲେ ଆପଣ ଆକୁ ଅପୋଜିଟ୍ ପାର୍ଟି କରିବେ ଅମୁକ ବର୍ଷ ଷ୍ଟେଟ୍ ଭର୍ସେସ୍ ଏକ୍ସ ତ ଆଇଓ ତ ଇନଭେଷ୍ଟିଗେଟ୍ କରୁଛି ଆଇଓ ପାର୍ଟି ହେଲେ ହେଇଯିବନି। You must understand where we are heading. And these persons who are fighting for their rights, you have permanently damaged their case. Accusation बहुत पूरा है थी वो कहना महाराज चित्रकला बहुत दिन लगा कंप्लीट
98,
कराएं
98,
आगे
98.
ताबी जानना 93
Yeah, accusation.
ଆପଣ ଏପଟ ଏରିଆ ରହନ୍ତୁନି କୋଷ୍ଟାଲ ଏରିଆ ଲୋକ ଜାଣିଥାନ୍ତି ଯେ କୋଉଠି 93 ର ନୋଟିଫିକେସନ
Notifications.
ତ ତା ପୂର୍ବରୁ ଆପଣଙ୍କର ପ୍ରୋସେସ ଆରମ୍ଭ ହେଲାଣି ଅଲରେଡି ୟୁ ହାଭ କମ୍ପ୍ଲିଟେଡ 93 ମାନେ 33 years you have completed. You have permanently damaged the case. WS कोठी अछि section 18 रे WS by the state project proponent कोठी अछि
No doctors.
This is how you damage the case. In the hurry to get adjudication, you permanently damage the case. And EP Awas and Vikas Nigam को मसला case 95 मत लाଗୁଥିଲା ଏଟା ନୂଆ କେସ୍ ଟା ବୋଲି
No, no, it is 90.
95 ର यूपी आवास आसे 95 ରୁ the law has been settled since 95 और next sorry वाला sentence complete है कि नहीं the learned counsel for the appellants has adjournment to address the above legal propositions केबे
2 weeks time.
The matter shall be listed under the same heading. 6 ये जो excitement of getting enhancement without impeding the party that has spoiled the case actually. Now I have dictated the order सिर्फ आपण कोन देखले गोटे चालची भलो जे कि ना डब्ल्यूएस अछि ना किछि आपण इशू कोठी फ्रेम हिच जजमेंट रे कोई शुड आंसर हिच जजमेंट रे देखछो नि जजमेंट देखछो
In judgment, no issue is framed.
इशू फ्रेम हिच
Issue go.
देखले लिखा हला फ्रॉम द राइवल कंटेंशन ऑफ बोथ द पार्टीज
Court has
राइवल की आपनकर
rival land action officer.
suppose he says that किछि पैसा दिया होनी let us assume or he says that माने आपनकर एकर को 10,000 जगह रे दिया लक्षे he is a rival to you बतन मु पार्टी करी सिविल जो सीनियर डिवीजन because he is a rival he determines distributes and that is the reason sir lawyers to educate in our system the judge only acts as an umpire you educate you and both Mr. Mahantis now he will continue as PK not SC both SC and PK will educate me and I will adjudicate आपण लेखाला पारा 3 रे लेखा गला राइवल कंटेंशन गुटिए कंटेंशन आपण खाली कहउछन जे मते 3 टका दरकार yes next
Item 3.
The case was disposed 21/1/2022. When it is not complied, I filed the contempt, and that the first contempt was disposed of 4/11/2022. When that's
second contempt hela
it was the second contempt.
the third no
No, second. First contempt, page 11
Mr. Lenka I mean there is no concept
of second
I mean
contempt.
contempt of courts act first was the to be punishment but anyway Mr. Jitendra Kumar Mishra आपण 1 लिखु ना कोन
हम 2 लिखि जे किंतु एथरे आसेने आपण लिस्ट रे
अच्छा
page 11
Jitendra Kumar Mishra 2 for the petitioner -2 Mr. D.N. Lenka, AGA for the opposite party, alleged contempt. The petitioner is before this court alleging non-compliance of the order dated 21.01.2022 passed by the coordinate bench. Stop. Thereafter, the petitioner had filed CUNTC number 3673 of 2022. alleging non-compliance of the earlier order dated 21.01.2022. Stop. The said contempt application was disposed of by the said coordinate bench. Granting for the 3 months time from the date of production of the certified copy of the order passed in CUNTC number 3673 of 2022. The writ petition was disposed of, granting how much time?
That somebody.
Sure. The writ petition did not give, had not specified any outer limit for the authorities to act upon the said order.
Hello, 1 second.
Please.
Page, annexure 3, page 12. Director directed the DO to submit the information.
So that is the compliance part.
Okay.
So I am saying that whether
No.
Prathamaটা se jodi time deythile boleni, that I wanted to understand on the reply. Yes. Para. ଆପଣ ଅର୍ଡରଟା କମ୍ୟୁନିକେଟ ହେଇଛି ବୋଲି ଡିଡିଜାକ ଅର୍ଡର ଲେଖିଛନ୍ତି
ଆଜ୍ଞା ପୋଷ୍ଟାଲ ରିସିଟ୍ ପାଖରେ ବି ରଖିଛି.
The Lord Counsel for the petitioner has stated in the petition that both the orders were communicated to the authorities. So the Lord Counsel for the petitioner submits that he has retained the postal receipts, forwarding the copies of the certified copies of the orders to the authorities. Contempt ସବୁବେଳେ ସେଟା ଫାଇଲ କରିବେ. Contempt ର essential ingredient ହେଲା notice. ମୁଁ ବହୁତ ଜାଣିଛି, I am more than confident. ଆପଣ ନ ପଠେଇଥିଲେ ମୁଁ କହିଦେବି. But then everyone will laugh at me that pleadings ରେ ନାହିଁ କି ଆପଣ annex କରିଦେବେ ଯେ communicated on such and such date. That is the first order. Second, first essential ingredient for non-compliance contempt होची communication. Because willful and deliberate violation. To bring in the criteria of ingredient of willful and deliberate, notice has to be sufficient. And it has to be within 1 year also. If you have a problem, stop. The Lord Counsel for the petitioner submits that he has retained the copies of the postal receipts, indicating the forwarding of the copies of the orders by speed post.
Yes, speed post.
By speed post. By speed post. Stop. Stop to comma, though not annexed to the writ application. It is submitted, further submitted by the director लिखिले को page 12
page 12 DO submit कले सब
मोर कॉज लिस्ट बाहर पड़लानी आपन उल्टा आपन जेरॉक्स रे पछपटे कोन लागितले कि
नहीं
मोर कोन एमपी कोन हेगला
कॉज लिस्ट
सर को देखंतु
कॉज लिस्ट से देई के
नहीं मो सर कहउचंदी जे गोटे चिट्ठी अछि बोली
हां चिट्ठीटा होती पेज annexure 3
13/9/2000
पेज 10 अच्छा नहीं से 12 कहले मु 12 खोलली तो
पेज 10 annexure 3
he is ahead of you. Mr. Lenka is ahead of you. Page 10 कौन लिखे Annexure 3, letter dated 13/9/2023 of the District Education Officer Khordha. Annexure 3, कौन लिखे office letter dated 3/9/2023 issued by the District Education Officer Khordha to the Director Secondary Education Odisha, indicates that the DO is aware of the orders. He has forwarded the same to the Director Secondary Education with copy marked to the Joint Secretary to Government School and Mass Education Department. You'll appear, Mr. Lenka.
yes
The ऊपर तारे डीएनए का लिखे होता है एटा तो फ्रेश पेन
Yes.
ऊपर लिखो तुम appearance the learned counsel the learned AGA Mr. D.N. Lenka upon advance copy served appears and submits that he shall obtain instruction from the opposite.
I have received instruction today morning.
So
On 12/1/2000.
you file that affidavit.
Yes.
Let him be satisfied with that. He seeks further time to obtain instructions regarding compliance of the order and file affidavit. List in the week commencing 13/4/2026. Mr. Lenka, at times they don't understand also what they are doing. So after looking at this annexure 3, then you be satisfied that they have done the after annexure 3 they have proceeded further.
Yes, this letter today I got that indicates that so they have sought for certain information, the date of.
No, I mean, they are proceeding in complying with the order that you are saying. How much time they have sought for?
Your Lordship may call it 3 weeks after.
He is saying 13 put. Yes. যদি comply କରିଦେବେ ଗୋଟେ definite time ନିଅନ୍ତୁ it is better to adjourn the matter than ବାରମ୍ବାର list କରିକି list occupy କରିବା କଥା.
Your Lordship call it.
13/4. Yes. Yes, please. Next.
Item 4,
May I please urge? As per as per direction of the Honorable Court,
You are Mr. Ponda is appearing or you are appearing?
I am appearing on behalf of Mr. Panda, my lord.
Mr. Rajiv Lochan Patnaik on behalf of Sunil Kumar Ponda for the petitioner.
My lord, as per last order, my lord, I have filed all the
Which order, sir?
dated 9th March 2026, your lords. Sorry, my lord, 7 March.
Read the order. Para 3. Para 2, can you read the order?
My lord, para 2, that during pendency
The
of
petitioner husband.
the petitioner is husband, my lord.
Read para 2, sir.
In the affidavit, my lord.
No. The order जोड़ा अपन comply करचंदी कोचंदी. In terms of the earlier order, you have filed certain things. So first replace the order, then I will go to the compliance. सेठी देखी दियो तू.
The petitioner husband is before this court challenging the judgment dated 15 January 2026 passed by the Leonard George Family Court, Burger.
In CMC so and so.
The petition was filed by the wife in the marriage and minor child, then aged about 11 years, seeking monthly maintenance rupees 15,000 for both mother and child to be paid by the husband father. The same she was favored, however, directing monthly maintenance rupees 6,500 to the wife in the marriage and rupees 4,000 in the minor child from the 22 July 2022 to 30th 11 2025, which was further directed monthly maintenance to be paid rupees 7,600 and rupees 4,600 from 1st 12 2025 onwards. The amount due from 22/2022 till 30/11/2025 is rupees 4,20,000 and from 1/12/2025 till 1/3/2026 rupees 36. In total amount being rupees 4,56,600 rupees. However,
Can read further, sir.
but the Honorable Apex Court in Rajneesh versus Neha and another
Have held that.
and that the money awarded to the wife as maintenance is the nature of the money decree. Since the petitioner seeking to challenge money decree, the Learned Counsel for the petitioner adjournment to obtain instruction, the petitioner to secure the said decree. The Learned Counsel for the petitioner shall also file the details, the payment already made pursuant or in the said proceeding or any other proceeding. In between matter, I have filed on 9th March 2026.
So when I asked you for to file the evidence, I don't require any evidence. I am not a trial court. I cannot reopen.
No, I am not.
So if you have paid anything,
My lord.
ask the person to prepare. You simply prepare a table on which date, how much.
Yes, that has been mentioned in the affidavit, my lord.
ଆପଣ ତ ରଚନା ଲେଖିଛନ୍ତି
ମାନେ
ଏଥିରେ ରଚନା ଲେଖନ୍ତୁନି sir, don't waste time sir, your time, my time is wasted sir.
Okay.
By reading a ମାନେ novel type ର ଆପଣ ତ simple ଆପଣଙ୍କର order ହେଲା 15/1/26 ରେ
My lord.
ଆପଣ ଯଦି ସେ ଗୋଟେ ଡେଟ୍ ଫିକ୍ସ କଲେ ଡେଟ୍ ଅଫ ଆପ୍ଲିକେସନ ଏଗେନ୍ ରଜନୀଶ ବର୍ସେସ୍ ନେହା
ମାଇନର
ସୋ ସେ ତା ଭିତରେ ଯାହା ଦେଇଛନ୍ତି ବିକଜ ୟୁ ସି ଦିସ୍ ଇଜ ଦ ଇଣ୍ଟରେଷ୍ଟ ଅଫ ୟୁର କ୍ଲାଏଣ୍ଟ
ମାଇନର
ହି ମେ ବି କନଫ୍ୟୁଜ ବଟ୍ ଆପଣ ତ ତାକୁ ଲାଇନ ଉପରକୁ ଆଣିବେ ନା
ମାଇନର
କୋଉ ତାରିଖରେ କେବେ କଣ ଦେଲେ ସେଟା ଗୋଟେ ପ୍ରିପେୟାର କରିବେ
ଆଜ୍ଞା
so that he will stand by his version
I will file
because in these kind of matters don't stiff your neck out don't make a statement that he has paid
next time
ସେ କଣ ଦଉଛନ୍ତି ଜଣେ ଏଠି କହୁଛନ୍ତି ମୁଁ ସୁକନ୍ୟା ସମୃଦ୍ଧିରେ ଗୋଟେ ଡିପୋଜିଟ କରିଛି ଯଦି ସେଇଟା ଡିକ୍ରିରେ ସାଟିସ୍ଫାକ୍ସନ ହବ ସେଇଟା କିଏ କହିବେ ଯେ ଟ୍ରାଏଲ କୋର୍ଟ କହିବେ ଯେ ସୁକନ୍ୟା ସମୃଦ୍ଧିରେ କରିଛନ୍ତି ସୋ ଦିସ୍ ଆମାଉଣ୍ଟ ଲକ୍ଷେ ଟଙ୍କା ହେଇପାରେ ପସିବଲି ଦ୍ୟାଟ ଇଜ ପସିବଲ ମୁଁ ଧରନ୍ତୁ ଜଣେ କହିଲେ ଲଟରୀ ଖେଳିଛି ଲଟରୀ ଲଟରୀ ଉଠିଲେ 10 ଲକ୍ଷ ଟଙ୍କା ଉଠିବ ତ କୋର୍ଟ ମେ ବି ସାଟିସ୍ଫାଇଡ୍ ବଟ୍ ଦିସ୍ କୋର୍ଟ ଡଜଣ୍ଟ ହାଭ୍ ଏନି ରୋଲ୍ ଦ ଲୟର ଡଜଣ୍ଟ ହାଭ୍ ଏନି ରୋଲ୍
yes sir
so they let them state it
how I have filed
it is
deposit memo. I already have filed minor in this
depositions
memo which has been
you just simply prepare a chart so ଆପଣ ଯୋଉଟା ରିଲାଏ କରୁଛନ୍ତି ତାକୁ ଯଦି ଆପଣ ଟେବୁଲାର ଫର୍ମରେ ରଖିଦେବେ it becomes very simple
okay
even I don't like ମୁଁ actually multiply କରୁଛି monthରେ I request them that ଆପଣ ଧରନ୍ତୁ ଏଥିରେ ହେଇଛି କେତେ 4,000 ଟଙ୍କା
4,56,000 ହେଇଛି
ସେଟା calculation ଟା ବି I try to reflect the reason being that you will also understand ଆପଣଙ୍କର 1/12/25 ରୁ ଯେତିକି ହେଇଛି ତା ପୂର୍ବରୁ ଗୋଟେ 22 ରୁ 25 ଗୋଟେ ଆମାଉଣ୍ଟ ଅଛି
ଆଜ୍ଞା
yes
may I pray one thing lordship kindly issue notice to the
no
so
you read in a revision application the Supreme Court has commented lack of application of mind and part of High Court if he does he is playing around with you if he has paid you would have filed an affidavit one line affidavit you don't have you see the direction is one line he files a essay of 10 paragraphs
yes
I cannot entertain Justice Deepak Mishra's judgment if you read Samima Faruqi the scope of revision application para 20 if you want do you want a citation
Yes, sir.
Samima Faruqi is 2015 into bracket 5 SCC 705
yes sir
ଆଉ ଯଦି ଆପଣ ଏବେ ତ ନ୍ୟୁଟ୍ରାଲ ସାଇଟେସନ ଆସିଗଲାଣି 2015 INSC all capital 283 ଆପଣଙ୍କର ଏଟା କ୍ଲିକ୍ କଲେ ଆସିଯାଉନି ଯୋଉ ସୁପ୍ରିମ କୋର୍ଟ ସାଇଟରେ ବଟ୍ ସେଥିରେ ଆପଣଙ୍କର ଆନୋଟେସନ ନାହିଁ ମାନେ ହେଡ୍ ନୋଟ୍ ହେଉନି କିନ୍ତୁ ଜଜମେଣ୍ଟ ପାଇଯିବେ para 19 and 20 of ACC 3
yes sir
and if you read the Supreme Court judgment Supreme Court has analyzed High Court may be correct in thinking that because he has retired he has to pay less amount but the reason for interference in a revision is very scope has been defined because if the court has taken note of the evidence on record and the language used is justice has been done language is used so that is enough the High Court should not interfere this attitude of not paying anything is not to be protected by you or me because law is made by the parliament then article 141 other judgments
well I will file
even you just look at it the affidavit itself shows that he has not complied ଆପଣଙ୍କୁ ପଚରା ହେଲା କେତେ ଟଙ୍କା ଦେଇଛନ୍ତି ଆପଣ କହିବେ ମୁଁ 10 ଟଙ୍କା ଦେଇଛି 10 ଲକ୍ଷ ଦେଇଛି ଆପଣ 5% ଲେଖୁଛନ୍ତି ନା ଜଣାପଡ଼ିଲା ଆପଣ ପରୀକ୍ଷାରେ ବ୍ୟବହାର କରାଯାଏନି ଯେ ଉତ୍ତର ଆସୁନଥିଲେ ସେ ଲେଖାଯାଏ ସମୟ କରାଯାଏ ଆପଣ ଦେଖିବେ ସେ ସବୁ ପେଜରେ ଗାରେ ପକେଇକି ତାପରେ ଗୋଟେ ଜିରୋ ବଡ ଜିରୋ ଦିଅନ୍ତି it is something like that and he is not telling you the truth unfortunately you are the best guide for him where he stands ଆପଣଙ୍କର କ୍ଲାଏଣ୍ଟ ମାନେ ମିଷ୍ଟର ପଣ୍ଡାଙ୍କ କ୍ଲାଏଣ୍ଟ you are the best guide that you should be confident that the lawyer will advise him he should ask you I will not pay then is there any way out suppose you answer no because it's a mandate of the statute now Supreme Court has intervened And execution is another problem. Mr. Patnaik, execution has to be completed. Rahul Shah. That is a larger bench decision of Supreme Court.
Well,
These decisions, both Rajneesh and Rahul, have been forwarded by Supreme Court to all the judges.
I will file on the next date.
So you ask him that he should pay. Then he challenge.
They already paid.
One lakh. So he's not disclosing that.
In para 8, disclose that.
So evidence is the way.
That
question is that it's not a question of negotiating something. He has a right. You need not request the court even. If he has given, he has to say, जे आपनकर से जो पीरियड फास्ट पीरियड होची 22 रु 30/11/23 माकरे गला आपनकर
4,20,000
नहीं पीरियड कथा मु कहूची पण अमाउंट तो कैलकुलेशन हेची
फ्रॉम 22/7/2022
1/12/25 रु 1/3/26
36,000
whatever.
So at present he was paid 1,12,000.
There is nothing. He's not doing charity to the court. 4,56,000 रु आपण जदि 1,12,000 देइचंती
age because my lord he is working as assistant teacher and getting rupees
there Samima Faruqi says that Supreme Court, the High Court does not have that jurisdiction. Same ground High Court I'm judgment padibo Samima Faruqi re it will appeal to you. High Court has given good reasons. The Supreme Court has said that it is not correct.
I am ready to pay the arrear
readiness convert कर दियंतु act रे अपन को readiness को provision अच्छी CPC रे if the judgment debtor is if it is a
but a humanitarian ground
नहीं सीधा sir CPC रे humanitarian grounds रे the appellate court has power revision रे power as humanitarian ground
the High Court has inherent power man.
Exactly अपन समय पार की पढ़ी नांती बोली struggle करचंती
I guess
we are being watched when you argue in a revision humanitarian ground I would have called earning capacity of humanitarian ground earning capacity is a matter of evidence.
Yes sir
आपनकर से जो मागितिले तुरंत आपनकर जदि कंसीडरेशन हेई न थांता से आपनकर एते कम पैसा देई न थांते केते टाका मागितिले से
मागितिले 15,000 टका
15,000 टाका
12,200
हां सो एंड से ताकू प्रथमे 10,500 देले
हां thereafter
what has considered the material कौन थिला WS कौन थिला सेडा जो देखियो पड़ियो
I am admitting that I am getting rupees 30,000 per month my lord.
That is sir सेटा तो आगो जिंस आपण परमानेंट एलिमनी भले त कैलकुलेट करि होबनी 30,000 हेली भी तो स्टिल इट इज इन द लेसर साइड तो आपण 30,000 रु पुराटा दे दियंतु आपण 80 टका रे चलंतु
at least 25% आबा कथा मैं
सेटा परमानेंट एलिमनी
no my lord in the maintenance case
20% रे आपण त 7,500 आपण चलंतु
7,500
आपण 7,500 नेकी तांको 7,500 बाकी पैसा एफडी रहि जाय
I have a responsible my ailing parents are there my lord
ailing parents for parents ailing hele wife or child पाइबेनी सीधा develop हेनी you are struggling because you are not following law you are giving a speech I have that limitation
sorry man I
am really impressed
I will file
I have all sympathy
I will file time
but I will not invite that comment of Justice Mishra an application of
yes sir I will file time
अपन देखो नु केते कोडे जंकर पेंशन ग्राउंड रे हाई कोर्ट रिड्यूस कर देले read that judgment it has been beautifully the way the Justice Mishra writes at the Chief Justice Hon'Ble Chief Justice then was it has been analyzed in fact if you go through I mean Rajneesh versus Neha or Samima Faruqi or even Rahul Shah the Supreme Court has collated no new point has been
in Rajneesh versus Neha also the Honorable Supreme Court had clearly stated that before passing any order the court shall consider the status of the parties that has been
mentioned consideration if the court awards the meager sum of 10,000 then whether that requires adjudication or picking of evidence in a 125 that you must understand आपण जदि से 30,000 कर देई थांते ताहले कोन थांता दिसे पॉइंट ता देरे सेटा it would have been the predominant point to be adjudicated से 4,000 जण को देले आ जण को देले 2,500
6,500
टोटल आपण तापरे डिवोर्स केस रे झियो रे कोन रोल अछि चाइल्ड रे कोन रोल अछि तार भी किछि नाही सेक्शन 18
My lord.
Section 18 ରେ କିଛି ନାହିଁ ସେଇଟା actually. ଆପଣଙ୍କର this whatever has been done in Rajneesh versus Neha is consideration of the judgments.
My lord.
ଅନିତା ପଟ୍ଟନାୟକ ଏଇଟା କିଏ ଦେଲେ ଆପଣ ଦେଲେ
Yes.
କୋଉଟା ଅଛି ଓ ସରି ଆଉ ଲେଖି apparently the Lord counsel for the petitioner refers to the order dated 7/3/2026 wherein elaborate discussions were made paragraph 2 and 3 directing the petitioner to file affidavit. The petitioner shall file affidavit in one page indicating the date of payment, proof of payment, and the amount paid at the next date. List in the week commencing. Sarah Child.
My lord, till date may be entering.
No, you are not paying, sir. You are bargaining. ଆପଣ 4,60,000 କୁ 1.5 ଲାख ଟଙ୍କା ଦେଇ କହୁଛନ୍ତି ମୁଁ ସବୁ ଦେଇ ଦେଇଛି
Khali see, they have filed.
sir. You must read. That's the problem, sir. Unless you read Rahul Shah, unless you read Samima, unless you read sir, he will come with a Dukhbari kahani. You are a lawyer not to tell any Dukhbari kahani because you are seeking somebody's rights. You don't require court sympathy. Court has to give you. That should be your approach.
Yes, sir.
Formality part जोटा अपन जो address मते करचंती कि bowing down कि मुंह छुड़ा ले, that is our I mean कौन, you can say the chair or the profession, but you are basically fighting for somebody's right. If he has a right, you have to. There that is how sympathy clause is not there. Sympathy, humanitarian ground, don't give any money because husband, wife and the child are not humans. In one judgment, Justice Mittal has written in that constitution bench where they have said that the constitution court should not direct fixing time limit. He has given a supplementary in the pursuit of doing justice, we do injustice. This line he has written. I have mentioned in some because many occasions you will find that the prayer is made expedite trial. In that context, he has written.
Obligers.
Yes.
Item 5,
The joining upon you are
May I please, Your Lordship?
you are Mr. A. Mahanti.
No, Sivasankar Chain.
ସିପିସନ ଅଛନ୍ତି 2 ଜଣ ଅଛନ୍ତି ଆଉ ଜଣେ ବି ଅଛନ୍ତି ଆଇ ଏମ୍ ସିଓର ସେ ଆଉ ଟିକେ ପତଳା ହେଇକି ମେ ବି ଇକ୍ୱାଲି ହ୍ୟାଣ୍ଡସମ୍ ଆଜ୍ ୟୁ ବଟ୍ ଆଉ ଟିକେ ପତଳା I thought him to be Mr. Sivasankar Chaini for the petitioner. Yes, sir.
My Lord, the petitioner is the wife, opposite party is the husband. Husband has filed a petition before the Hon'Ble Judge Family Court Baleshwar under section 11 and 12 of the Hindu Marriage Act 1955 to declare the marriage void. And the opposite party has,
What is the status of trial there, sir?
my Lord, the case has been posted for conciliation on 4th April 2026.
Conciliate, sir.
My Lord,
The problem is that the mandate of the Supreme Court or the law is that the matrimonial matters should not be kept pending because it affects families, lives, like as you said, the humans.
yes, my Lord. My Lord, my
So the child, the in-laws family, both the boy and the girl, at least in every matrimonial matter, 12-14 persons are involved. Now you are seeking interference to stall the proceeding for conciliation.
No, my Lord. My humble submission is that the petitioner is residing now.
Sir, residence, as far as conciliation is concerned, suppose now he wants conciliation where? She wants conciliation where?
Bhadrak.
Bhadrak. So can I direct that Bhadrak is a better place for conciliation?
No, my Lord. Matter is not also
So
that.
how can it be? You must
Madam.
understand,
Madam.
wherever the wife wants conciliation, the High Court will direct there.
Yes, sir.
Section 24, have you read? Under which provision you have filed?
Yes, madam. Under section 24.
So what is the provision in section 24?
Yes, madam. That is my question, my Lord. My Lord, because the Hon'Ble Judge Family
Upon the 24 କହିନାହାନ୍ତି, that is my question କହିଲେଣି।
name.
24 କଣ ଅଛି?
My lord, 24
Language कौन use ହେଇଛି?
my lord, section 24 deals with the general power of transfer and
अरे ମୁଁ ଯଦି क्वेश्चन पचारिबी सेक्शन 24 रे कौन डील ହେଇଛି तार आंसर कौन हबो?
my lord, it transport.
सब क्वेश्चन का गोटे आंसर. Sir, I am asking you very specific. If you are seeking transfer under section 24, then what is the language used in 24?
My lord, on the application of any of the parties and after notice to the parties and after hearing such of them as desire to be heard or his own motion without such notice, the High Court or the District Court may at any stage transfer any suit, appeal or other proceeding pending before it for trial or disposal to any court subordinate to it and competent to try or dispose of the same, or withdraw any suit, appeal or other proceedings pending in any court subordinate to it and try or dispose of the same.
पढ़ुଛନ୍ତି ଆପଣ ମୁଖ୍ୟ ଜିନିଷଟା ପଢି ନାହାନ୍ତି. Looking at the convenience of the parties plural. ଆପଣ ତାକୁ କହୁଛନ୍ତି convenience of one party.
My lord,
କୋଉଠି ଲେଖା ହେଇଛି convenience of section 24 ରେ? କୋଉଠି ଅଛି ଯେ convenience of one party?
my lord,
अरे माइलॉर्ड केमती मो माइलॉर्ड को कन्वेंस एथिरे पडिनी अपन सेटा पाइले कि अपन सब पहुंचनी से जेटा पाउ कि ना पाउना तथापि वो बेसी छोट हो जाई ना कोन अरे अक्षर बेसी छोट हो जाई छोटिया वीडियो दर्शते आपण सीपीसी बड़ हवा दरकार apply to have the suit transferred to another court and the court to which such application is made after considering the objections of the other parties, if any, shall determine in which of the several courts having jurisdiction the suit shall proceed. Now read section 9. Section 9 टा देखो
court to try section 9 CPC.
हाँ मोर समान नाम मोर भी से आज courts to try all civil suits unless barred. So if you read time and 24 together, there is no scope of entertaining view of one party only. And then the concept of dominus litis. The husband staying at Balasore, where he will file the suit? He will file the suit at Balasore. And you are the problem is that you are frustrating the conciliation.
My lord, that is the question, my lord. The husband really is not living in the Baleshwar. He is, his house is in.
Who will adjudicate that? Section 19, look at 19.
Yes, my lord. That is the.
Yes, my lord. 19, yes, my lord.
My lord, under
Section 19 of Hindu Marriage Act.
My lord,
So the problem is that if you raise a question of fact, can this court determine?
Yes, my lord. That is under section 24.
You have to win the case or lose the case. You are the defendant of the petitioner.
My lord, I am the petitioner, my lord, in this case, and opposite. Before the trial court, I am the respondent.
You are the respondent. You want to lose the case or win the case?
No, I want
No,
to.
my lord. Trial court.
I want to win the case, my lord.
Yes. So if there is a case of wrong jurisdiction, territorial jurisdiction,
Yes, my lord.
you will win or lose.
My lord, I'll win the case.
So then why you are interested to get the transfer and get it posted to the court having jurisdiction?
Because, my lord,
If you are not following them. If you want to, you say that the plaintiff has filed a suit at a wrong place, which doesn't have jurisdiction. Who will decide that? High Court. First of all, High Court cannot decide. It has to be decided by the trial court itself.
my lord, that is.
Kindly listen, sir. This habit of always blabbering something, just leave it. You allow the court to complete the sentence. Because the problem is if you continue for now 20 minutes, after the 20 minutes, I will ask this question, again you will be struggling. There is a purpose. It is not that I am interested to speak to you. You are saying that the husband doesn't stay in Balasore and stay somewhere else. So which is the jurisdiction in Hindu Marriage Act?
Under section 19 of Hindu Marriage Act 1955.
If section 19 is violated, then the husband will lose the case. You will win. Then why you are interested to transfer it? Why you are not taking that plea that you do not have jurisdiction?
Because I have to each and every day I have to attend the
appeal to VC. Have you not applied for? Have you applied? It has been rejected.
No, madam.
Whenever a notice is issued by any court anywhere, now the transfer application is filed to stall the proceeding at the stage of conciliation. And we are asking the trial court that you complete the matrimonial causes because it involves two individuals, their life, their family. You apply for ICT. The learned counsel for the petitioner was heard at length. Judgment अच्छी जो section 9, section 24 of CPC. Then there is section 19 of Hindu Marriage Act. Detailed judgment emerged. Argued by Mr. Haripada Mardi. He also argued well. You have also argued well. But the thing is that you should give some more time in interacting with the court. It's not a debate competition. My purpose is that suppose you argue till 1 a.m. I ask this question that if you are a defendant, the suit is filed before a court of lacking jurisdiction. Then you will win the case. You want the suit to be dismissed or you want separation. Declaration to be that he wants 11-12 application. You want to win the case? Then this is the best strategy that simply you file the preliminary objection that this court does not have jurisdiction.
Kindly observe that one.
What I will observe?
I will file primary issue.
ଆପଣ ଚାମ୍ବର ଜଏନ୍ କରିଛି କହୁନାହାନ୍ତି ସେଟା ହେଇପାରିବନି ଆଜ୍ଞା ବହୁତ ଫ୍ରିରେ ଆଡଭାଇସ୍ ଦିଆଯାଉଛି and if I would have practiced you would have never come to me to seek advice in matrimonial matters. You would have gone to Ms. Sinha. It no, but ଆପଣମାନଙ୍କର ଯୋଉ argument that is baffling. Defendant coming to High Court says that the suit is filed before a court having lacking territorial jurisdiction and it should be allowed to a court where the court will have territorial jurisdiction. It is really baffling. ଆପଣ କ'ଣ legal strategy କରିବେ? So why I am discussing because you have to open up your mind. ଯିଏ ଆସିକି ଆପଣ ଯାହା ଦୁର୍ଗତି କାହାଣୀ କହିଲେ ଆଜ୍ଞା ଗୋଟେ ଆପଣ ତ ଟ୍ରାଏଲ କୋର୍ଟ ଲୟର କଣ୍ଟାକ୍ଟ କରିଥିବେ ଆପଣ ପିଟିସନର ଆପଣଙ୍କ ପାଖକୁ ଆସିନଥିବ. This is a typical strategy of stalling any conciliation.
No, here my lord, the writ petitioner is appearing, but the opposite party is not appearing. But the husband is not appearing in the conciliation since last 2.
Again, sir, that is very more. That is not only baffling, that is laughable. When the plaintiff does not appear, defendant appears, there is a CPC specific achieve.
Conciliation will
the consolation will be say provision ଆପଣ କାଇଁ ଫାଇଲ କରୁନାହାନ୍ତି ନା ଆପଣଙ୍କର 6ଟା କେସ୍ ଆପଣଙ୍କ ଅଦର ସାଇଡ୍ ଓକିଲଙ୍କର 6ଟା କେସ୍ 6ଟାରୁ 3ଟାରେ ଆପିୟର କରୁନାହାନ୍ତି ମ୍ୟାଡାମ ସିନା 3ଟାରେ ଆପିୟର କରୁନାହାନ୍ତି ତେଣୁ ଆପଣଙ୍କ କେସରେ ସିଏ ଫାଇଲ କରିବେନି ସିପିସି ଆଉ ତାଙ୍କ କେସରେ ଆପଣ ଫାଇଲ କରିବେ ମ୍ୟାଡାମ ସିନା ଡୋଣ୍ଟ ମାଇଣ୍ଡ ଆଇ ଡୋଣ୍ଟ ବ୍ଲେମ୍ ଦ୍ୟାଟ୍ ଆପଣ ସେଟା କାଇଁ ଫାଇଲ କରୁନାହାନ୍ତି ସେ ଆପ୍ଲିକେସନ.
It is in the
and the other problem in those bars is that it is driven by the motives. You should lead. I don't say that you'll shift your practice to Balasore or Bhadra. The message is that you should, talk and speak and write as a lawyer. ଏଠି High Court ରେ କହୁଛନ୍ତି ଆଜ୍ଞା ସେ ରହନ୍ତିନି ବାଲେଶ୍ୱରରେ କେସ୍ ଫାଇଲ କରିଛନ୍ତି. You listen to the YouTube. If that stand you can take, you should take before the trial court. Sarla. Section 19 is a bar or not? Section 9, because Section 19 is a special statute. 9 is the broadest. Any court, any suit. Unless there is a bar. 9 and both 9, but 9 has to be read subject to 19 because it's a special statute. Yes, that order I will pass, and I cited last. The Lord Counsel for the petitioner was heard at length. Opening statement I'm going to. Petition. You take your seat, I'll take some time in dictating the order. The petitioner wife in the marriage is before this court seeking transfer of the. I don't mind you sitting. If you like standing, no problem. But I'll take some time. The petitioner wife in the marriage is before this court seeking transfer of the CP number 585 of 2025. Pending before the Lord Judge, Family Court, Balasore. The said CP has been filed by the husband in the marriage under section -11 and 12 of the Hindu Marriage Act. Seeking a declaratory relief. That is, the court, so-called marriage dated 24/11/2024 between the petitioner husband and the respondent wife, as alleged and claimed by the respondent to be nullity. Respondent for a quotents. To be nullity, full stop. It is submitted that submitted no apna TRP se annex karchanti nahi ki gote notice annex karchanti na
My lord, annexure
or annex kon ethire katiala
page 10, my lord, annexure 1.
te mo brief ru kati jaychi. The notice issued in the bookmark kon karchanti guys. Bookmark re nahi annex. The notice dated 15 September 2025 issued by the Lord Judge, Family Court, Balasore has been annexed. Soft copy अच्छी मैं खोल के देख चुका हूँ अपना. आपको bookmark रे entry करना है. Been filed. अच्छा तो आप annexure वन रे प्रिया तोड़कू नहीं चलती बट नहीं प्रिया तो ठीक है किंतु सेटा से नोटिस टा बोधे मिस दे चलते. अच्छा ठीक है आपण फाइल कला नोटिस टा भी ता सारे बांधी को फाइल कर दे चल. Okay, the copy of the plaint has also been annexed in the said annexure. So it is submitted by the Lord Counsel for the petitioner that the petitioner wife stays with her parents after her marriage has run into rough weathers at Bhadrak. Bhadrak re rohuchandi kohuchandi.
My lord,
Petitioner wife koti rohuchandi?
petitioner is the wife.
Koti rohuchandi?
Bhadrak. Hayurbhanj. Yes, sorry, my lord, Bhadrak.
Is that Bhadrak?
Naikindi.
The said address has also been indicated in the CP, cost title of the CP. Stop. It is further submitted that the husband ସେଟା ଲେଖିବି ନା ଲେଖିବିନି ଆପଣ ଯାହା କହିବେ husband ରୁହନ୍ତିନି ବୋଲି ବାବାଲେଶ୍ୱରରେ ଯୋଉଟା କହୁଛନ୍ତି. It is further submitted that the husband petitioner before the allotted trial court does not stay within the jurisdiction of the state court. State court lacks jurisdiction. Lacks territorial jurisdiction. Territorial jurisdiction. Stop. ତାପରେ ସେ ମ୍ୟାଟରଟା ସେଟା ଥିଲା ଭୁବନେଶ୍ୱରରୁ ବ୍ରହ୍ମପୁର ମତେ ପଚାରିକି ମୁଁ କହିଦେବି ଆଉ ତାପରେ ICT ଟା ରହିବ if the petitioner applies for apply କଲେ ତାଙ୍କୁ allow କରିବି but that will be considered in accordance with law କରନ୍ତୁ ସେଟା you have to evolve that way yes the petition stands disposed of yes
Item 6.
May please your lordship, my lord, why petitioner filed this case to transfer the
Pashwini Sinha for the petitioner Ajit Pati blank yes Miss Sinha
to transfer the case filed by her
Which stage ରେ ଅଛି
ସେଟା ସେ ନୋଟିସ ଆସିଥିଲା ନୋଟିସଟା ଆମେ ପାଇନଥିଲୁ ଯେହେତୁ ସେଟା ଏକ୍ସପାର୍ଟ ହେଇଯାଇଥିଲା ଆମେ ନାଉ ଆପିୟରିଂ
order 9 rule 13 ଫାଇଲ କଲେ
ଆଜ୍ଞା
କଣ order ହେଲା
ଆମେ କଣ୍ଟେଷ୍ଟ କରିବା ପାଇଁ କି WS ଦେବା ପାଇଁ କି
WS ଗ୍ରହଣ କଲେ
କରିବେ କହିଛନ୍ତି
ଆପଣ ଟ୍ରାନ୍ସଫର କାହିଁ ଚାହୁଁଛନ୍ତି
transfer the wife residing at Katak is parental house
ଜଗତସିଂହପୁରରେ ଆପଣ ବି କିଛି କେସ୍ କରନ୍ତୁ କଣ ଅସୁବିଧା ଅଛି
ଆଜ୍ଞା
ଜଗତସିଂହପୁର କେସ୍ ଗୁଡାକ ଆପଣ କିଛି କରନ୍ତୁ
ଜଗତସିଂହପୁରରେ ନାହିଁ ଭୁବନେଶ୍ୱର ଅଛି କଟକରେ ଜଗତସିଂହପୁରରେ ନାହିଁ
ଆପଣ ଭୁବନେଶ୍ୱରରୁ କଟକ ଚାହୁଁଛନ୍ତି
ଆଜ୍ଞା wife filed a section 9 petition
ଫାଇଲ କରିଛନ୍ତି ଭୁବନେଶ୍ୱରରେ
yes only to harass the petitioner
ହାରାସ କଣ ହବ କେସ୍ ଫାଇଲ କଲେ ହାରାସମେଣ୍ଟ ମୁଁ ଏପର୍ଯ୍ୟନ୍ତ ବୁଝିପାରୁନି କୋଉ ପ୍ରୋଭିଜନ ରେ ଅଛି ଯେ
ନାଇଁ ସେ ଏଠି appear କରିଛନ୍ତି
ଆଜ୍ଞା ସେକ୍ସନ 9 ତ ଆଜ୍ଞା ବିଲକୁଲ ସେ ହାରାସମେଣ୍ଟ କଥା ନାହିଁ
Section
ସେକ୍ସନ 9 ଏନି କୋର୍ଟ କ୍ୟାନ୍ ଟ୍ରାଏଲ ଏନି ସୁଟ୍
section 9 ରେ ଏଠି ଫାଇଲ wife file କରିଛି
CPC jurisdiction କଥା ମୁଁ କହୁଛି ଆପଣ ଯଦି
Jurisdiction.
କହିବେ ଯେ ହଜବେଣ୍ଡ ଖୋଜିକି ଯିବ ଯୋଉଠି ଏବେ ତ ଗୋଟେ ଫାଇଲ ହେଇଛି ସେଥିପାଇଁ ଯେ ୱାଇଫ କଲେଣି MBA କଲେଣି ସମ୍ବଲପୁର ଟ୍ରାନ୍ସଫର ହେଇଯାଉ
wife
ସେଟା କାହିଁକି କରାଗଲା ନା ଯେହେତୁ ହଜବେଣ୍ଡ ଏଇ ଆପଣ ପ୍ଲି ନେବେ ବୋଲି ଆପଣ ନଟ୍ ଇନ୍ ୟୁର କେସ୍ ୱାଇଫ କ ଯୋଉଠି ରେସିଡେନ୍ସିଆଲ ଟାଉନ ରେ ବରଗଡ଼ରେ ସେ ଫାଇଲ କଲେ ଆଉ ତ କିଛି ପ୍ଲି ନାହିଁ କଣ କରାଯିବ ତ ୱାଇଫ ଆଡମିସନ କଲେ ସମ୍ବଲପୁର ୟୁନିଭର୍ସିଟି MBA ତା ସମ୍ବଲପୁର ବର୍ତ୍ତମାନ ଟ୍ରାନ୍ସଫର ହବ ତାପରେ ସେ ଯଦି କଟକ ଆସିବେ କୋଉଠି ତାଙ୍କର ଫର୍ଦର PhD କରିବା ପାଇଁ କଟକ ଟ୍ରାନ୍ସଫର ହବ ଆଣ୍ଡ ଗଡ୍ ଫରବିଡ୍ ଯେ ସେ ଯଦି ଯିବେ ଲଣ୍ଡନ ଯିବେ କୋଉଠି LSE କି କୋଉଠିକି ଯିବେ ତାହେଲେ କଣ ହବ ଜୁରିସଡିକ୍ସନ ନାହିଁ these are not tenable you have heard Mr. Chaini he argued so well but the problem is I don't know how if I start adjourning and transferring all matters as the place that there is no provision in statute
section 9
ଆପଣଙ୍କ ଏଥିରେ ୱାଇଫ କେତେଟା କେସ୍ ଫାଇଲ କରିଛନ୍ତି ହଜବେଣ୍ଡ
section 9 under section 9
ସେକ୍ସନ 9
only
ସେଟା କଟକରେ
କଟକରେ କାଉନସିଲିଂ ସେଣ୍ଟରରେ କେସ୍ ଯେତେବେଳେ ଥିଲା କନସିଲେସନ ରେ ହଜବେଣ୍ଡ appear କଲେନି କାଉନସିଲିଂ ଫେଲ
ଆଗ କୋଉଟା ଫାଇଲ ହେଇଛି
ଆଗ wife ଫେଲ କରିଛନ୍ତି
ଆଗ ସେକ୍ସନ 9 ଫାଇଲ
yes
then you have some credible ground to argue no otherwise if I record these things then it becomes impossible to offer a court to pass orders because then the issue will be then only the jurisdiction is gender specific section 9 section 19 nowhere indicates that section 9 is clear 19 of Hindi Marriage Act is very clear
yes.
so if unless that is not suppose a court is taking up a matter violating 19 then that plea is available upon by the best place eta because upon a restitution file korchanti
yes
13 you want to be dismissed or you want allowed 13
no
you want to register so 13 if section 19 is violated in you will take the plea before the court that this case is not maintainable before so and so court Bhubaneswar in view of the provision contained in section 19 then you have won the case this logic of the whole thing has got confused and lot of pressure on the system Bhubaneswar dita court hela pore bhi still there is pendency but yes you are saying that after receiving section 9 notice he has that is a credible logic reasonable logic not
yes.
credible of course anyone saying is correct and Ms. Tapaswini Sinha for the petitioner opposite party blank you take your seat I'll dictate the order The petitioner wife in the marriage is before this court, seeking transfer of the CP (223) of 2025, pending before the Learned Judge, Family Court, Bhubaneswar. Stop. भुवनेश्वर आम जगतसिंहपुर कहते आप भुवनेश्वर जाए सबुदिन केस कर मोर सीनियर माने समस्ते भुवनेश्वर जी फास्ट हाफ रे कहे तुम देख उपरओल से आसवे एंटायर बिकॉज प्रोलिफिक प्रैक्टिशनर्स आई लर्न विथ देम वर्किंग विथ देम सेकंड फास्ट हाफ रे तो भुवनेश्वर केस कर कौन तो एसोसिएट चक्रवर्ती बाबू जाउछन्ती जाजपुर जाउछन्ती भद्रक जाउछन्ती सबडे जाउछन्ती आप भुवनेश्वर केस आपण करिया कथा बोर्ड कहीं कहली कहले मैडम a simple reason 2025 रे केस फाइल हैला अर्ली पार्ट नाउ आई ट्रांसफर इट टू कटक इट बिकम्स द केस द मैटर ऑफ 2026 इट लूजेस इट्स प्रायोरिटी आल्सो आपण डब्ल्यूएस कहले ना डब्ल्यूएस फाइल क्वेश्चन विल सेट करिबे माने इट हैज बीन अलाउड सो इट इज लाइव देयर सेठु आसी एठी पडिले गला इट पडी कि रहला एंड यू नेवर नो इट विल गो टू सुप्रीम कोर्ट suppose I am allowing transfer, it will go to Supreme Court. There is a reason, man. There should be some, I mean, thought process in. Will stop. The said CP, kindly take your seat. Said CP was filed by the husband under section 13 into bracket 1, comma, small I, comma, into bracket I-A, bracket closed, comma, I-small b, bracket closed, of the Hindu Marriage Act, comma, 1955, read with section 7 of the Family Courts Act, seeking dissolution of the marriage solemnized between the parties on 1010.07.2055. Referring to the annexure 1 of the annexure 1 to the petition is submitted by the learned counsel for the petitioner wife is that application under section 9 of the Hindu Marriage Act for restitution of conjugal rights was filed by the wife before the learned judge, Family Court, Contempt. That is civil proceeding number 180 of 2025. Is submitted. The minor girl child is born from the wedlock. And a girl child has been born. The couple have been blessed with a child from the wedlock. Stop. The baby girl stays with the mother. Issue notice along with this order. आपण भुवनेश्वर को जाउनांती मैडम कोचन जे आपण भुवनेश्वर केस कटो ट्रांसफर करू छन
ना से पिलाटा अछि आ भुवनेश्वर हम जाउनो
काय आपण जाउनांती
भुवनेश्वर ना बहुत
आपण तो समस्त गले भुवनेश्वर
हमहु भुवनेश्वर बोल लागे
हम तो जज डाकी चैंबर पहुंचे जाए तमे कोन एकुटी एटी कोर्ट रे आ कोडे गले तो मुझे अधे कहले आपण कहि जे भुवनेश्वर अछि इंजेक्शन सूट अछि सकाळे टेक अप हेछि
भुवनेश्वर कथा
सर जिबे होंडा सिटी जोरे जाय के आसीबे सेटा कोन कहि सूट होई रहे भूगोल अलगा बोर्ड ऑफ डिविजन जजेस ऑनरेबल जजेस वर काइंड ऑफ अलगा डाकी पचरे तुम कोडे गले तुम कोन सकाळे एकुटी अच्छा I have at least faced this question from 3 judges, very senior judges.
ସେତେବେଳେ ଯୁଗ ଥିଲା ଭଲ
ଯୁଗ ନାହିଁ, ଭଲ ସେଟା
କଥା କଣ କଲେ
ଆପଣ ଇଏ ସମାନ
ଭୁବନେଶ୍ୱର
ଆପଣ ଯାଜପୁର ଯାଉଛନ୍ତି କଣ କଟକ ଭୁବନେଶ୍ୱର କଣ ଯାଉଛନ୍ତି?
ସବୁଆଡେ ଯାଉଥିଲୁ ଭୁବନେଶ୍ୱର ବନ୍ଦ କଲେ କାରଣ ଭୁବନେଶ୍ୱର ସେଟଲମେଣ୍ଟ କରିଦିଅନ୍ତିନି
ଭୁବନେଶ୍ୱର ତାପରେ ଏଇ କେସଟା ଆପଣ ସେ ଡବ୍ଲ୍ୟୁଏସ୍ ଫାଇଲ କଲେନି ଏଠିକି ଆସିବ 2026 ମସିହା କେସ୍ ହେଇଯିବ ବର୍ତ୍ତମାନ।
ଡବ୍ଲ୍ୟୁଏସ୍ ଆମେ ଏକ୍ସପାର୍ଟି ଯେହେତୁ ହେଇଥିଲୁ ଡବ୍ଲ୍ୟୁଏସ୍ ଫାଇଲ
ଆଇ नो
ନୋଟିସ୍ ସବମିଟ୍ କରିଦେଲେ
କରାଯିବ ସେଇଟା ତ
ଆମେ ଏଠି କଟକରେ କି ଭୁବନେଶ୍ୱର ଆଡ୍ରେସ୍ ଘର ସବମିଟ୍ କରି ନୋଟିସ୍ ପଠେଇଥିଲେ
ଯାହା ହଉ ସିଧା ଆଟଲିଷ୍ଟ କୋର୍ଟ ହାଜ ବିନ୍ କନସିଡରେଟ୍ ଆପଣଙ୍କର ଡବ୍ଲ୍ୟୁଏସ୍ ଫାଇଲ ହେଇଛି
ଏଇଟା ବି
along with this order requisites for issuance of para କରି ଲେଖିବେ ଆପଣ ଗୋଟେ ସେଣ୍ଟେନ୍ସ ଟା ମିଶେଇ ଦଉଛନ୍ତି ସେଟା ଇସ୍ୟୁ ନୋଟିସ୍ ଟା ଗୋଟେ ସପାରା କରି ସପାରା requisites for issuance of notice by speed post with registration and proof of delivery be filed within 5 or 7 within 7 working days
ଆମେ ଆଜି ଫାଇଲ କଲୁ ଗୋଟେ ଥାଉ
because again defect ହେଇକି ଉଠିବ ଫେରେ 7 working days list after SR liberty to mention IE number 51 of 2026 the IE has been filed seeking the prayer stay of further proceeding in CP number 223 of 2025. Stop. Hard learned counsel for the petitioner. She reiterates the submissions as noted above. She reiterates the submissions as noted above. Stop. Issue notice as above. Stop. Sapara. Sapara issue notice as above. Then Sapara. Requisites for issuance of notice. Sorry, accept one set of process fee. Accept one set of process fee as well as postal requisites along with the petition. जो लिख रहे हैं इश्यू नोटिस ऊपर है रिटर्नेबल डेट अपन नेक्स्ट डेट केबे अछि कहउछन
एप्रिल लोटे के बोलिया
भुवनेश्वर रे एप्रिल आज के तारीख होची आज होची 18 तारीख रिटर्नेबल डेट बी फिक्स टू 25 1 तो 15 4 2026 the matter shall be listed in the listed for orders in the week commencing 20 4 2026 अपन एटा नोटिस इशू होला पर कोथरे आछी after notice the matter shall be लिखो matter shall be listed in the week commencing 20 4 2026 the CP number 223 of 2025 pending before the learned judge family judge dash Roman 2 all capital Bhubaneswar shall be adjourned to a date beyond 20 तारीख कहले 15 20 beyond 27 4 2026 as would be convenient to the learned judge learned court in season of the matter upon a prayer being made for the said purpose. Liberty to mention. सीटा तो ऊपर लिखियो लिस्ट आफ्टर एसा लिबरिटी टू मेंशन तो अच्छे सेटा तळकु नै लिखो रिपीट काई करे तो रिपीट कर देबे अब जदि आईएट अलगा हबो ताले यस
Item 7.
May I the petition is the wife my letter and okay the husband my letter.
yes
So husband filed my letter CP number 20725 annex 1 for my letter doubt kila.
आपण कोन पे आपण 13 ना आपण
9 ने फाइल कर
आपण कर नहीं ताले तो ताले मिस्टर मिश्र अच्छा सॉरी ताले मिस्टर मैडम सिन्हा कर तो नोटिस जो आपण करे पड़ियो बात नहीं
DB केस with the wife filed at Borgad at annex 2 my letter to minor
आप 498 करछन ना नहीं 307 498 थोड़ा भी कर थोड़ा से जाई ना
ना जाए ना
ठीक है So Bharat Bhushan Rautray for the you take your seat I'll take this order. So Bharat Bhushan Rautray for the petitioner. अपन एटा को मसिर पेंडिंग अछि 25 सीपीटा 207 टा फाइल करछंती वाइफ
नहीं हस्बैंड फाइल करछि
अपन ताकू 26 रे फाइल करछंती डीबी
DB टा हां
सो दिस इज तो आपनकर फैक्ट्स आर डिफरेंट
maintenance ନାହିଁ କିଛି ନାହିଁ
ମେଣ୍ଟେନାନ୍ସ ଆପଣ ଯୋଉଠି ନାହିଁ ସେଠି ଫାଇଲ କରିପାରିବେ ସେଠି ବି ଆପ୍ଲିକ କରିପାରିବେ ବଟ୍ ସେଥିପାଇଁ ଟ୍ରାନ୍ସଫର ହବ କେମିତି ହବ
ସେ ରାଉରକେଲାରୁ ସେ ବରଗଡ଼ ଟ୍ରାନ୍ସଫର ହବ 250 kilometers away from ବରଗଡ଼ the two daughters are there
ଏତେ ବାଟ ତ ନୁହଁ କିନ୍ତୁ
220-30
250 ହେଲା ଯେ ବୁଲି ବୁଲି ପହଞ୍ଚିବେ ଆପଣ କଟକରୁ ଭୁବନେଶ୍ୱର 20 କିଲୋମିଟର ଆପଣ କଟକରୁ ଚାଲିଗଲେ ଏଠି କୋଉଠି ଗଲେ କପିଳାସ ରୋଡ ସିଆଡୁ ଗଲେ ଢେଙ୍କାନାଳ ଆଡକୁ ସେଠୁ ପରେ ଲେଫ୍ଟ ଟର୍ନ କରିକି ଗଲେ ଇଆଡେ ଏ ଯୋଉ ବ୍ରିଜ ରେ ବାହାରିଲେ ସେଟା ତ ନୂଆ ରାସ୍ତା ହେଇଯାଇଛି ନା
ବରଗଡ଼ ରାଉରକେଲା 230
କ୍ରସ କଲେ ତାପରେ ଚାଲିଗଲେ ମୁଣ୍ଡଳି ସେ ମହାନଦୀ କ୍ରସ କଲେ ମୁଣ୍ଡଳି ଯାଇକି ବୁଲିକି ଆସିଲେ ହେଇଯିବ 50-60 କିଲୋମିଟର ହେଇଯିବ The petitioner is the wife in the marriage. Yes, take your seat and take it. She has approached this court seeking transfer of the CP number 207 of 2025 from the Court of Learned Judge Family Court Rourkela to the Court of the Learned Judge Family Court Borgad. It is submitted that the petitioner is staying with her parents at se ko rohuchandi na poduchandi boli kauchandi fine
ରହୁଛନ୍ତି ଦିଟା ଝିଅ ତାର ପଢୁଛନ୍ତି daughters are there
ଆପଣ ଆଡ୍ରେସ ଦିଆ ହେଇଛି ବରଗଡ଼ ବୋଲି
ସେମାନେ ବରଗଡ଼ରେ ଅଛନ୍ତି ପରା ପ୍ୟାରେଣ୍ଟସ ଅଛି
ଆଚ୍ଛା ଆପଣ ରାଉରକେଲାରୁ ବରଗଡ଼ ଚାହୁଁଛନ୍ତି
ଆଜ୍ଞା
and stays with her parents at Borgad after her marriage has run into rough weather. So, the petitioner is in distress as she is not getting any maintenance, any amount towards her maintenance from her husband. Stop. It is further submitted that the seeking financial assistance, the petitioner wife has filed all capital CMC space DB then NO 38 of 2026 under section 12 of the Protection of Women from Domestic Violence Act, 2005. The said matter, pending, which is, right, stop, which is pending before the Court of Learned SDJM Borgad. Stop. Well, issue notice along with this order. Sapara issue notice along with this order. Then Sapara. Requisites for issuance of notice by speed post with registration and proof of delivery be filed within
7 days.
Within 7 working days. List after SR, liberty to mention. I8 रे same returnable date same कर देबे repeat कर देबे है ना पण I रे ना बुझ पाले ना नहीं आइटम 6 रे आपण देखले एथरे रिटर्नेबल डेट टा शेयर कर देबे केते हिज ऑर्डर रिटर्नेबल डेट 15 है ठीक है आज हो 18 तो रिटर्नेबल डेट 15 लिस्ट वीक रखिन 20 से अर्जन हो बियॉन्ड 27 समान रहला यस सर
Item A,
Mr. R. Mahato for the petitioner.
Your my lord, the
Party
petitioner,
blank. Yes, Mr. Mahato.
petitioner being the wife has preferred the present transfer application seeking transfer of the CP case number CP proceeding number 48 of 2026 pending before Judge Family Court Jajpur to Learned Judge Family Court Kendrapada.
ଯାଜପୁର କେନ୍ଦ୍ର ପାଖ ତାପରେ ଆପଣ ଆଇସିଟି ରେ ତାପିୟର କରିପାରିବେ
My lord, the
ଏଇଟା ଆପଣ ଅପୋଜ ଏଇଟା ଆପଣଙ୍କର ସିପି ଟା କଣ ପାଇଁ ଫେଲ ହେଇଛି
it is section 13, my lord.
13
As because, my lord, and under annexure 2, we start from page 14, my lord.
yes
One proceeding of maintenance was already prepared by the wife before the Judge Family Court Kendrapada. In the said proceeding,
ଆଗୁଆ
husband had
କୋଉଟା ଆଗ ହେଲା ଆଗ 13
maintenance age.
ଆଗ maintenance
Ago age. In that case, my lord, already husband has appeared and filed his objection. I have given the objection also. Annexure 2 series, my lord. Objection start from page 20.
okay
On that score, I have prepared the transfer application.
And thereafter he has filed CP, you are saying.
CP he has filed on the month of February, my lord.
ଆପଣଙ୍କର 125 ଟା କେବେ ଫାଇଲ କଲେ?
125 ଟା 2025 ମସିହାରେ ଫାଇଲ ହେଇଛି on
ଆଚ୍ଛା ଫେବୃଆରୀ 26 ଆପଣ କହୁଛନ୍ତି? ସେଟା
CP ଟା ଫେବୃଆରୀ 26 ରେ ଫାଇଲ।
ହଁ, that looks like hazy ହେଇଯାଇଛି ସେଟା okay. So I'll dictate the order, take your seat. So R Mahato, you belong to Ranchi?
My lord?
Your native place is Ranchi or Odisha?
No. My native place is West Bengal.
West Bengal.
Yes.
I had a client actually from Ranchi. You take your seat. Stay good. The petitioner before this court is the wife in the marriage. Stop. She seeks transfer of the CP number 48 of 2026 pending before the Learned Judge, Family Court, Jajpur to the court of Learned Judge, Family Court, Kendrapada.
Yes, please.
Kendrapada. So, the CP has been filed by the husband in the marriage under section U/S dot 13 into bracket 1 into bracket Roman I-A bracket closed of the Hindu Marriage Act, 1955. Had learned counsel for the petitioner, it is submitted that the petitioner, after her marriage has run into rough weather, stays with her parents. Stop. She is distressed as she is not receiving any amount towards her maintenance from the husband. Stop. She has filed application under section 125 of CRPC. I'm sorry, under section 144 of BNSS, 2023. Child is there.
No, madam. No issue.
Stop. Comma, then IE, that is, comma, criminal proceeding number 130 of 2025. Pending before the Learned Judge, Family Court, Kendrapada. The opposite party has appeared in the said proceeding. Opposite party, comma, petitioner in the present application, comma, no dash. Opposite party, dash, petitioner, dash, husband in the marriage has appeared in the said proceeding and has filed his written statement. Stop. Stop. ऊपर जो लिख लें कि अपना ट्रांसफर ऑफ सीपी फाइल्ड इन द मंथ ऑफ February 2026. It is stop. Issue notice along with this order. Requisites for issuance of notice by speed post with registration and proof of delivery be filed within how much time, sir?
5 working days.
Within 5 working days. Para. Returnable date be fixed to 17/4/2026. List. The matter shall be listed in the week commencing 27/4/2026. तापर लिखिए आइए. Had learned counsel for the petitioner, he reiterates his submissions as noted above. The IA has been filed seeking stay of further proceeding in the CP. So and so पढ़ना लिखिए. Pending before so and so. Stop. Para. As an interim measure, it is directed that the CP number 80, pending before 80, shall be adjourned to a date beyond 4/5/2026, subject to the convenience of the learned judge, the learned court in season of the matter, upon a prayer being made for the said purpose. Urgent certificate copy character. Yes, next please.
Item 11.
I beg pardon, my lord. One small prayer is there.
Correction.
No,
Sorry.
in item number 16, my lord.
Yes.
I want to take a fresh step for the notice. That is,
Step maybe.
again,
How much time?
within 5 days, my lord.
7 working days. Right? Thing too, but take a correct notice. I'm
Yes.
sorry. Discover present correct address.
Yes, my lord.
Don't take repeated notices in same address.
No, no, my
It doesn't feel serve any purpose. You have found out the correct address and give it.
Yes, my lord.
ठीक है. केबे आसियो 16टा मिस्टर बारिक 27 से नोटिस देबो फ्रेश नोटिस जीवो एई परिबो तो फ्रेश नोटिस हां 27 रिटर्न. Yes, Mr.
Item 11, I am the petitioner wife. Being agreed by the order of enhancement of Judge Family Court, Jajpur, I have preferred this revision. Though the revision was
Signature ही न है कि पळे आसला
आज्ञा?
सीधा गला एडी रिटर्न विदाउट सिग्नेचर हे गला
किए मतलब दीटा आरपीएफएम करते जोटा डिसमिस हो गलानी मूल ऑर्डर अगेंस्ट एथिरे रिसीव कोना जाजपुर स्टाइल
रिसीव करछन
जाजपुर स्टाइल हो कोन एटा ओके मोर मेमो अधोदित
जाजपुर काई जाउछन आपण तो भुवनेश्वर जिबे आपण काई जाजपुर जाउछन ए भलिया प्रॉब्लम
जाजपुर केस हम पाको आसे आ कोन करबा जेहेतु मिस श्रीलंकर गाँटा जाजपुर
से कौन अच्छा से आउथर नियंतु नोटिस ना से कोड अपियर करछंती
एग्जीक्यूशन अपियर करथबे मु सेटा
से इंस्ट्रक्शन नियंतु
एटा लिस्ट थाउ ऑर्डर
लिस्ट ऑर्डर आसु बट द प्रॉब्लम इज दैट आपण इफ यू हैव इंस्ट्रक्शन यू कैन टेक नोटिस आफ्रेश
फ्रेश नोटिस
एटा एक्चुअली तारकर नो एटा हमर भूल माने हमर सिस्टम रो भूल
हम सिस्टम रो
बिना सिग्नेचर एडी आडी कोन दरकार थिला
दस्खत करी आनिया कथा थिला
तो ताठू बेटर होचे माने एडी हजि जिबा सो दैट आपण जो प्रोविजन होचे सीपीसी रे से सफिशिएंट बिल धरा हो यू आर इन ए कैश 22 सिचुएशन नाउ मिस्टर चक्रवर्ती फॉर द petitioner. Mr. S. Sanjeev Chakraborty for the petitioner. Sanjeev Chakraborty for the petitioner. এটা 11 মিনিট 9-10 আজ নেই. Office note put up by the registry indicates that the notice in admission pursuant to the order passed by the coordinate bench dated Ete has been returned to the registry without signature of the recipient. Deliberate भी ही पर he may be right. It is deliberately एटा करा है so that it is neither here nor there. By the coordinate bench by order dated 22/7/2019.
आज्ञा
7 वर्ष ହେଇଗଲାଣି.
मोर मेमोरी रफ खाता
The learned counsel for the learned
मेमोरी रफ खाता ହେଇଗଲାଣି
The learned counsel for the petitioner seeks accommodation to obtain up-to-date instruction. List for orders in the week commencing 13/4/2026.
आपण कोर्ट बोली उठिला आला
नहीं
ना मेमो बहुत देली चेष्टा करछि बहुत चेष्टा करछि मैडम तो गोड़ गोड़ी तो मैडम कर दौड़ी दौड़ी
In fact, it is a coincidence. I was just discussing at the today. I tried to send some message at the beginning. I said that those who are starting the profession, they can't afford a good advocates club. They put the fees down and so it is better all members are allowed and let us try to list it. That is experimentation.
ଏବେ ବି ଫାଇଲ ଅଛି 15ଟା ଖଣ୍ଡେ मेमो
ପ୍ରୋବ୍ଲେମ ସେ ଅଲଗା କୋର୍ଟର ସବୁ ମେନସନ ନାହିଁ ସେଥିଯୋଗୁଁ ସେ କୋର୍ଟରେ ଆକ୍ସେପ୍ଟ କରୁନଥିଲି ଏଇଟା ଫାଷ୍ଟ ଆମ କୋର୍ଟ.
Yes, next.
Item 12.
My lord, here from Mr. Malayaranjan Behra,
Yes, please.
I permitted to withdraw this.
Sir, kindly file. So, good memories. You have power here, sir. Apart na sir.
Vibhushan Rao.
What power nahi se jahar power achi tam kohibe dastat karibe. Never withdraw an application where you do not have power because it has serious consequence. Please appreciate. Se nahanti kono. Dastat kiye karchandi.
Memo deyi nahanti, memo debi.
ठीक है फास्ट करो आपण देले फाइल कर दो नोटेड आपन को नाटा होची विभूति भूषण राउत रे राउत सर मेमोटा देले आपण सेदा मेंस कॉल करिवे हैला गिव द मेमो ଆଣନ୍ତୁ ଯାଇକି ତାଙ୍କୁ କହିଦିଅନ୍ତୁ ଫୋନ କରିକି ଦେଇଦିଅନ୍ତୁ ମେମୋଟା କାଗଜ ଯଦି ନେବେ କାଗଜ ଦିଅନ୍ତୁ ଆପଣ ମିଷ୍ଟର ରାଉତ ମେମୋଟା ଲେଖିକି କହିବେ ମିଷ୍ଟର ବେହେରାଙ୍କୁ ସାଇନ କରିବା ପାଇଁ ଡୋଣ୍ଟ ସାଇନ ଦ ମେମୋ ୱିଥଡ୍ରଲ୍ ମେମୋ
He has sent me on the WhatsApp, but I did not send it. He sent me on WhatsApp, but
memo-ta original
is missing, so I did not file it.
नहीं मेमोटा ओरिजिनल दरकार मे बी मिस्टर बेहरा मिस्टर दास मिस्टर जेना एनीवन ऑन रिकॉर्ड एनी एडवोकेट ऑन रिकॉर्ड कैन फाइल but not a proxy counsel. Please appreciate. Yes. Petitioner none. और एटा 13 रे एटा अपन ऑर्डर टा रिपीट होच कोटेशन में हैला ऑर्डर डेटेड 12/3/2026 para 1 ऑर्डर नंबर 2 para 1 para 2 हैला अपन लिखिबे none appears for the petitioner para 3 actually none appears for the petitioner so the matter is when the matter is called पर the petitioner is आपन के लोक अछंती डाकिवा लोक आपन तो कितो रहना अपन निजे उठी पड़ोसी ठीक ना the petitioner is also absent on repeated calls पर by the order dated 12/3/2026 the matter was adjourned, granting further opportunity to the petitioner with the following observations. Quote kar debe para 3 and 4. Para 3, 4. Quote. In view of the above, nahi avde parallel likhiya padibo. Quoting the same. Like you quotation la. Tapora paragraph hobo. Today the matter is in the cause list, which indicates within quote the matter shall be disposed of quote ends. Tapore in view of the above the petition is disposed of. Tapor nahi with indicated on likhle which paragraph hai tapore se add karibe. The office note also indicates the efforts of the registry to intimate the learned counsel for the petitioner. In intimating the next date of listing. Copy of the order dated 12/3/2026 was also forwarded to the learned counsel. No, नहीं सेंटेंस आउथरे पढ़ंतु of the registry intimate na indicate no intimate the learned counsel for the the order dated well cutting outhre likhon pura 12/3/2026 through the office of the learned secretary Odisha High Court Bar Association. ତାପରେ ଲେଖିବେ individual. The rest of the matters after recess. Anyone where both the parties are present, any date is suggested, he will do it. reflect the endorsement of the person who has corrected. तापरे लिखले तू हाँ तापरे today when the matter is taken up, memo of date is filed by the learned counsel for the petitioner, which states thus. In para, the petition stands disposed of. जो आमर एठी आगु रहुथिला साइड रे फाइल रखिया पई the system कोन गोटे बेंच वाले रहउ नथला इन सेठी जो लॉयर्स माने रखु छथि से तळे थोय पडु झरका पर रखा होतला गोटे छोट डेस्क सुप्रीम कोर्ट वाला गोटे रहिले साइड रे. Yes, next. Really? 14 order dictate is 15. Petitioner none. 15 mention करथिले कि मार्क करछन्ती आपण
मेंशन है
किछि मेंशन है नि दा ओ none appears for the matter. None appears for the petitioner when the matter is called. The petition was presented before this court. Petition was presented before this court on 23-23. And 3 years have passed since then. Correct. The matter shall be listed for orders on or in the week commencing 33 करिवे नहीं परिवार 33-20-26. The next date of listing and the order shall be communicated to the learned counsel for the petitioner on record. Yes, next.
16.
Mr. R. Mahato for the petitioner. Opposite party blank. Stop. The office note indicates that the Department of Posts postal tracking report suggests that notices issued pursuant to the order dated 18/11/2025 passed by the learned passed by the coordinate bench. Notices were issued, were issued. Stop. The notice has been written and answered with comments returned to sender in sufficient address. Quoted. But the learned counsel for the petitioner submits that he will take steps for taking notice afresh. Stop. Para. Prayer is allowed. Requisites shall be filed for issuance of notice afresh to the opposite party in the present correct address. Requisites shall be filed within 7 working days. Requisites shall be filed within 7 working days for issuance of notice afresh to the opposite party. Stop. Upon filing of the requisites, notices shall be issued by the registry. Stop. Unutilized copies returned, unserved shall be utilized. Returnable date shall be fixed to, as you could say, 18 will be fixed to 21/4/2026. List in the week commencing 27/4/2026. The 27 ଥିଲା ତ? Okay.
17.
Pass over. 17, yes, sir.
The Lordship direct the notices to go. The requisites were filed a month
Acha,
apart.
late ହେଇଗଲା.
Yes, sir.
Acha. Your name, sir?
A. Prasad.
Mr. A. Prasad for the petitioner. It is submitted by the learned counsel for the petitioner that due to inadvertence, requisites for issuance of notice as directed by order dated 09.02.2026 could not be filed within
Lordship directed 7 days.
within 7 working days as directed. Para. केबे फाइल कले?
7/3/26.
The notice, the stuff, the requisites have already been filed on 7/3/26. Stop. Displayed that the requisites may be accepted and notices may be issued. Stop. Para. It is directed that the requisites filed late shall be accepted, notices shall be issued. Notices plural na singular?
Notice.
Notice will. Notices shall be issued as directed by order dated 9/2/2026. The returnable date shall be 27/4/2026. 22/4/2026. List after SR, liberty to mention.
Which was an interim order.
Interim order as passed earlier shall continue till the next data listing.
Grateful.
Yes. The list in the week commencing 27. List in the week of 27. Yes.
18.
Mr. Rathod.
Yeah, please.
Your Madam Akanksha Kabi.
Yes.
Mr. Bhagavat Prasad Rathod for the petitioner. Ms. Akanksha Kabi for the opposite party. Yes.
With your permission, my lord.
Yes, please.
It is a matrimonial dispute, and the petitioner here, who is the respondent wife in the court below,
Yes.
take instruction from the petitioner whether the matter has been settled through mediation or not. They have a positive response. The matter referred to the mediation for.
Yes, madam.
And the petitioner, my lord, is a conducting lady advocate.
Your Lordship, the respondent wife had already approached this court in a different matter where she had filed for recalling of one of the parties. In that case, the matter was already referred to the mediation. And in the mediation, it was such a chaotic situation that on the second date of mediation, the mediation failed. They could not even give a third date. And the mediator tried her level best to make the party aware of the things, and the separation is since 2021. So if all the efforts have already been taken, and the same situation was also there in the conciliation which has taken place in both the civil proceeding and CRP.
I mean, according to you, who is the most chaotic? Both of them must be chaotic because it is a marriage made in heaven.
Yes, Your Lordship.
Because the chaotic persons marrying each other is a marriage made in heaven. It matches.
Your Lordship, the situation became very.
No, madam. Actually,
yes.
Ms. Kabi, actually, the issue is that mediation is not a thing which cannot be reattempted. The whole purpose is because we are passing binary orders. You would have marked that I am passing either rejecting or accepting or issuing notice. But in matrimonial disputes, the effort should be even there can be some some pattern in the chaos.
I completely bow down before Your Lordship on this point.
I'm not passing any order today. No, please, but please don't think that way. Don't go that far. I get your point.
But
in fact, I have seen myself in some mediations what is happening, and I've heard from other judges in
Your Lordship, this matter, this matter.
Volume. why I give this example,
I guess.
Ms. Kabi, is that that can be the experience.
Yes.
Yes.
When judges have most kind of experience,
Yes, sir.
I mean, not the mediator, at least they are called to High Court.
Yes, Your Lordship.
Even before they are so independent minded. They started. I don't know who are chasing whom to beat. I don't know, but another again you have to this sound that you get. अब mute करो तुम.
Sir, my humble submission is this was already attempted.
Correct.
And there is a strict instruction from my client, Your Lordship, that we also obtained an order for restricting the wife to meet us or communicate to us in any medium.
Right.
Because there is a standing order by the Learned Family Court, Bhubaneswar, not to come because
The family court must be a young person, directly elevated decisions, not having that much of experience. Because you see, these are not my experience. These are experiences what I have heard from my seniors.
Your Lordship, this is just a delaying technique on behalf of the wife.
I understand. But
In 2023, before the I may be permitted just to give one small submission.
Please don't take it that way.
Yeah, no, sir. Sir, just my humble submission. Since 2023, this matter was posted for evidence from the side of the wife, and she is filing petitions after petitions from 2023 to 2026 just to delay the proceeding of this case. Before the land, and I am being aggrieved. There is also a CRP petition which is pending, and in every month I am also paying in that. And this is just a delaying technique which she is adopting. And this.
Yes.
In response,
No. I mean, no orders today. Simple adjournment. You agree for a date. Next day, let us see. So we'll see. The motive for persuading you is that there is always a hope. I mean, when you say chaotic, I don't think you would have expected that this kind of chaotic experience I know.
Yes, Your Lordship.
These I have heard from horse's mouth.
Yes, Your Lordship.
I mean, the wife, while being examined,
what happened?
Hitting the husband because he asked certain questions. The husband falling on the lawyer falling upside down on the chair.
Yes, Your Lordship.
So those kinds of experience is possible in these matters only, and that is part of the legal experience also, you can say.
Your Lordship, that day on mediation.
State date.
Mediation, sir.
Mediation में पठेबी
आज्ञा चंपा
अपन मेडिसिन चारिपटे अपन बुलिए पे जगह भी नहीं बहुत बुढ़ा हो बुढ़ा गुड़ी हवा पे नहीं से
April 2nd week, sir.
Sir, my humble prayer is to
list in the week. ठीक अच्छी. I'm simply. I mean, I will not record your objection.
Yes.
But I'll record that you are suggesting.
Your Lordship.
Appearance लिख ले. It is submitted by the Lord Counsel for the petitioner wife in the marriage that there is possibility of the parties arriving at a settlement acceptable to both. Ms. Kavi, Learned Counsel for the opposite party, narrates her experience. Submits that earlier the several attempts made for conciliation, mediation have failed. Stop. Still, it is hoped that there is a possibility of the parties achieving a settlement acceptable to both. And the Learned Counsel for the parties are requested to pursue the same without being worried about the ultimate result, what they would achieve. List in the week commencing 6/4/2026.
ट्रायल कोर्ट रे अछि एप्रिल
Sir, April 7 पूर्वरु
सेटा मे को कन्वर्ट रे जो
मे को रखुन 30
ओके
33 रे रखुन
30
yes sir.
33 सर हबन सर
33 हेले नै सेटा कोन प्रॉब्लम अछि एक्चुअली सेतिरे
सर ट्रायल
23 सुनंतु देयर इज अ प्रॉब्लम बिकॉज़ द रीजन बीइंग the list on 6 तारीख रखते 6 तारीख रे ही रहूगा.
Yes your lordship. Yes
on 6/4.
Yes
because I think you have already moved for declaring 2 as a holiday.
ट्रायल कोर्ट दिन सर अछि अप्रैल
ताले 30 30 रखले हबो
आगे सर सर टिके आगु रखितले हम
मिस्टर 33
अप्रैल 6 था रो सर 33 इलेक्शन रो सर
ता पूर्वरु
इलेक्शन
ना ता पूर्वरु अछि फेरिस रे
28 रो
28
अच्छा भला आपण जुबिलेंट थिबे most of you will be jubilant. Yes.
6 April रो सर तब पॉजिटिवली ऑर्डर मैट्रिमोनियल disposed of for
several times.
No. She is very loud and clear, but more effective than you, or as effective as you.
But she is a extraordinarily brilliant girl. That's what I told her, that you play pattern, you will be able to educate yourself.
Why I am submitting?
I am a student of law. I'm a student of law.
But I understand this younger generation, my lord, when they come to this court, at least they will get themselves prepared.
They should. I mean, this is a very, that is the most important, what you call significant or beautiful, the way the adjectives. Our profession is like that. Every day you learn, you prepare, and you never know how much of preparation, but still court asks a different question. I think that is your experience at the bar, my experience.
360 degree of preparation you must have.
Why I am a hope, my lord? The dispute arises in the year.
Yes, my lord, please fixing my lord a date for
30th March is total.
6th April, my lord. The dispute arises in the year 2023. Till date, the husband, the wife shall not prefer any affair against the husband or his in-laws family members. That is the positive. Even if nowadays, fornicator is severely misutilized.
Mr. Ratha, she is in good company of lawyers.
Yes, she is an advocate.
So she should not file because then RPFM, TRPC. So anyway.
Your lordship, there is already an order. Yes, your lordship.
6th lord, my request to 6th.
So 7th. So matter is there.
ଆପଣ 30 କି 31st ରେ ଆସୁ ଗୋଟେ ଡେଟ୍ ଫିକ୍ସ କରନ୍ତୁ
sir it will maybe in March
31 ଦିନ ଆସୁ ଆପଣଙ୍କ ଯଦି hotel skips has scored 175 today now it has come in social media that he had a hangover but he started hitting so ଆପଣଙ୍କର ବି ଯଦି ବେଶୀ celebration ହେଲା 31 କୁ ରହିବୁ ତାହେଲେ
sir already there's an order of this honorable court for expedition in WPC number 7784 of 24 to dispose the case at the earliest. And that is not disclosed in their petition also before this honorable court. In their entire petition, this is not mentioned. And this order is 7/3/2024.
We were expecting that you will disclose.
7/3/2025. Already 1 year has already passed.
I am not
disclosing. The next petition will be filed for in Supreme Court to transfer it to another state.
Yes.
That is how Supreme Court, Honorable Apex Court has taken note of that.
Just
44 cases. In Orissa, I have found 37. Against each other. So 44 cases, the Honorable Court directed 10,000 cost to each and the marriage is dissolved exercising 142. But that power we are not having anyway.
Yes, sir.
19.
Sir, 31st of March for mediations.
No, mediation I have not observed because you so much.
Just
I only express my hope that you will work on it.
Yes. Much obliged.
Mr. Ratha. Where is Mr. Ray? Is he busy in election or what?
Madam,
provided
no,
copy.
rejoinder has not been filed. On the last occasion, he has taken time to file rejoinder.
Petitioner, none. Mr. Subhash Chandra Ratha for the opposite party. The Learned Counsel for the opposite party refers to the order dated 04.02.2026 and submits that rejoinder has not been filed. Stop. Accordingly, the matter is adjourned to grant further opportunity to the petitioner in terms of the order dated 4/2/2026. Ago first line lekhantu, the matter has been listed for hearing or under the heading for admission. Tapare eta likhibe. Yes. The date kuntu.
We commencing 4/5.
We commencing 4/5 hai.
Item 20. Paso.
Paso. Okay.
22.
22 date kar diyo sir. 22 की mention करना है. 22 matter is mentioned. The matter is listed for hearing under the heading for admission. For admission that single quote रहेगा, quotation में रहेगा. Non appears for the parties when the matter for the petitioner 22 होची. Mr. Behra, you are there. Right. The Prabhu Prasanna Behra for the opposite parties 21 TO2 1 TO2 3 or 1 2 and 3. Four and 5 none, 6 none. 6 में आप लोग appear करिए. हाँ. Yes. 1 TO2 3 and 6 कर दे. Yes. Four and 5 none. None appears for the party opposite petitioner and the opposite parties 4 and 5 when the matter is called. The matter is listed for hearing under the heading for admission within court. Let's stop. To grant further opportunity, list in the week commencing
27
27/4/26.
23.
I'm appearing for the OP number 5 now.
Petitioner none. The Prabhu Prasanna Behra.
43 is much clear.
Name of petitioner none now. Manoj Kumar Khuntia kinti. Petitioner none. Petitioner none. Mr. Prabhu Prasanna Behra for the opposite parties additional standing counsel for opposite parties 1 TO2 4. Mr. P.K. Satapathy for OP number 5. None appears for the petitioner when the matter is called. To grant further opportunity, the matter is the matter is listed for hearing under the heading for admission. To grant further opportunity, list.
We commencing 4/5.
4/5/2026. 2022 matter.
April matter termination ta.
Kale 27 April. Okay. Commencing 27/4.
24.
Mr. L. Jenna for the petitioner. Prabhu Prasanna Behra for the opposite parties. Lord Counsel for the petitioner seeks for the time to file. So Sudhir Patra पढ़ले आस्ते ले अच्छा So Prabhu Prasanna Behra for the opposite parties 1, 3 to 5. Mr. Sudhir Kumar Patra, standing counsel for OP number 2. The learned counsel for the petitioner mentions the matter. The matter stop the matter being in the list is mentioned by the learned counsel for the petitioner. Stop. He seeks for the time to file rejoinder. Stop. Accordingly, the matter shall be listed in the week commencing 24/4/26.
Item 26.
I am for the opposite party.
Twenty-six टाइम मेंशन कर लिया अपन मेंशन कर लिया
नहीं
25.
26 रे लिखि दियंतु 25 लिखंतु मिस्टर सहस्र ज्योति नंद फॉर द पिटिशनर opposite party none. The learned counsel for the petitioner submits that he has been informed by the learned counsel for the opposite party regarding his personal difficulty. Stop. The matter is adjourned. To be listed in the week commencing केते कले 25 24/4/26. You are Mr. B. Behra.
DP Das.
Sorry, Mr. DP Das. 26 petitioner none. Mr. DP Das for the opposite party. None appears for the petitioner when the matter is called. Learned counsel for the opposite party is present. Stop. The matter shall be listed. The matter is listed under the heading for hearing. The matter is listed for hearing under the heading for admission. To grant further opportunity to the petitioner, list in the week commencing 27.
27.
Yes.
My lord, here, my lord, in the sub item, I am the petitioner.
Yes.
My lord, here a recent development has been happened that the petitioner
By your client.
No. She was living.
So you have not filed any bail application for your client? Anticipatory bail or regular bail?
They are on under separation, my lord. It was the section 13 application filed by the husband. I am for the husband.
So, in fact, since you have not filed any application, that shows that he is innocent.
Yes, my lord.
Otherwise, you would have.
Because she is living with her paramour, and the paramour has killed her, and thereafter he has committed suicide. And today is the 9th day. Last Tuesday, that incident has been happened.
TRPC 323 of 2024. Petitioner none. State party achandi. Secondary state achandi. First ray
71 of 94.
323. नहीं नांदी. लिखले Mr. R. Mahato. The learned counsel for the opposite party narrates a very unfortunate incident regarding passing away of the petitioner. He submitted that she has died unnaturally. Stop. The learned counsel submits that. The learned counsel, Mr. Mahato, submits that. Opposite party like that. Learned counsel submits that. Learned counsel for the opposite party submits that. He will obtain further instructions in the matter. Stop. The matter shall be listed for orders next week.
Next week, then I can produce that UD case number or that copy.
Listed on 25 कर दियो 25 ना 26 अपन 18 एटा मार्च माने सेपरेट एटा मार्च
On 30th, my lord.
আচ্ছা
30th.
মিস্টার 30 ফর অর্ডার 30 দিন পারা টিআরপিসিআর 71 ରେ 71 ତାପରେ ଲେଖନ୍ତୁ ମିଷ୍ଟର ଆର୍ ମାହାତୋ ଫର ଦ ପିଟିସନର So Prabhu Prasanna Behra for the opposite party. OP1. Acha, Mr. Anshuman Sethi for OP1. Anshuman Sethi, additional standing for OP1. OP2 and 3, none.
OP2 and 3 for that already appeared, my lord.
No, today no one is appearing.
Oh, today no.
I am recording the appearance. I am recording appearance only.
Lord, I beg pardon.
But and what about the minor child?
Minor child is now within the custody of that parents of that Mamata Devna.
Very tragic.
Now the father, being the father, the present petitioner in TRP CRL, that now he is unable to get the custody of that child.
That is a win-win situation for lawyers.
Yes, my lord.
TRPC bail, then now there will be custody petition. তাহলে in view of the order passed in the connected tagged. In the tagged TRPC 323 of 2024, the matter shall be listed together with the said case on kete date kale 30 din. Yes, passed away, Mr. Mohanty.
Yes, my lord.
The petitioner has passed away.
But I talked today with her father.
Very tragic circumstances. I think she has suffered a homicidal death.
What my lord has said, my lord.
So I am posting it to 30 दिन जो लिखले नॉन लिखले मिस्टर मनोज कुमार महांती करे प्रथमटारे मिस्टर मनोज कुमार महांती फॉर द पिटिशनर द्वितीय मैटर मिस्टर अंशुमान सेठी फॉर OP1 मिस्टर मनोज कुमार महांती फॉर OP2 and 3.
They said that a lot of friends said that she passed away.
Yes. She has passed away, and she has been as it is been told. Being a court, I am not observing those things. And she has been killed, and the paramour has committed suicide.
I'll take instruction.
So the UD case has been what he has done a simple approach. He will simply obtain the copy of the UD case report. That will show that this lady has passed away. But regarding the minor child, this is maintenance.
Maintenance.
ठीक है देखिए. In fact, now the child is represented through the person who is passed away. So that again, that has to. But usually the cause of action will see the child may file through anyone else.
Maternal grandfather, maternal
whoever.
There. It will be substituted by maternal father.
No, the representative cannot be substituted. He has to file. The maternal grandfathers parents will father or mother, they will come up and say that we will now represent the child. Because now if the petition is not maintainable at the instance of a child.
Paramount consideration will be the welfare of the child. Where the
paramount consideration cannot confer jurisdiction.
Sometimes, my lord, I have to.
I am yet to come across that a child will come to court and say that that you substitute someone. So
last year,
no, perhaps you have not heard me. I said that the grandparents will come up and say that because child cannot file a substitution.
Child cannot file. Child can file through the grandfather.
Yes, they will. Now what they will say that we want to substitute ourselves, or they will say that we will represent the child. So that I want. That I told you. Yes, next.
May I pardon, my lord?
Yes.
Item 23, my lord.
Yes.
My lord, I am petitioner in one of the read. That is.
Acha, first matter or second matter?
My lord, on in 1848. Second matter, my lord. And
Mr. Pandey is there?
my
You are along with Mr. Pandey?
I am along with Mr. Manoj Kumar Khunti, my lord.
First.
No, first and second, both. Second, ମୁଁ ବୋଧେ opposite party ଅଛି. Second ମୁଁ opposite party ଅଛି.
ଆପଣ ଅଛନ୍ତି ମିଷ୍ଟର ଖୁଣ୍ଟିଆଙ୍କ ସାଙ୍ଗରେ? ଆପଣ ନାଁ ନାହିଁ, ତାଙ୍କ ଚାମ୍ବର ନାଁ ଗୁଡାକ ଅଛି।
First matter ମୁଁ ଅଛି sir. ନାଁଟା କାଇଁ reflect କରିବି ମୁଁ ଜାଣିନି ତ ଅଛି. My wakalatnama is there.
Item 23 ରେ ଲେଖିଦେବେ ମିଷ୍ଟର ଦେବରୟ S ଦେବରୟ
SD Rai man.
ST Ray for the petitioner.
And
connected matter re
in the second matter, my lord, I am for opposite party number 5 and 6, my lord.
So Satpathy was appearing for whom?
5 and 6 is the managing committee of Mahama UP school and headmistress come secretary of the managing.
22 re Mr. Swapnil Rai, you are there?
Yes, ma'am.
22 टा भी note कर दिया appearance. List 2 देखिए कर दे.
And my lord, another thing is that the first application there is stay is there, my lord.
Interim order is there.
Interim order is there. That may be
just one second. Letter copy. 22 रे Swapnil Rai कर दे.
22 रे भी interim order ଅଛି.
22 interim order to continue. 23 interim order to continue.
Deeply obliged.
In item 22 is state has to file a counter bill. It has not filed the counter till date. It files it. 2021 wrong matter.
You take note of that.
Yes, sir, I already. This is a matter relating regulation.
22 रे it is submitted by the line add कर दियो तो it is submitted by Mr. Royal Learned Counsel that state has not filed counter. The Learned AC submits that counter shall be filed by केबे डेट कले 22 टा केबे डेट करछंती
27 सर रूल कमिटी
फाइल बाय गुडे चेक by 21 check
because now the ravens
upon stop the counter shall be accepted by the next date upon serving a copy thereof on the Learned Counsel for the petitioner.
Because it's a matter relating regulation, we are employees under the Ravens University. The university has filed their counter. Accepting our prayer, they have decided.
University pay.
They have.
I am appearing for the university, my lords.
They have decided to regular. They have decided to regular our
Venugopal Mahapatra
services. They have decided to regular our services. The only difficulty is that the state is not approving it. The university is saying that we will regularize and all the expenses will be paid from the funds of the universities. In spite of that,
Mr. Prabhu Prasanna 1, 2, 2, 3, 6. So Venugopal Mahapatra for 4 and 5. 4 and 5.
My lords.
Swapnil Rai was the petitioner.
only that much limited point is to be adjudicated. When the university
प्रभु एतर बुझिबे और आपण रेगुलराइज करंतु कहलेनी.
My lords, we have actually proposed regulation to absorb them against vacant post. We had sent it to Higher Education Department. Higher Education Department rejected it. Against the same, they have now the grievance lies, my lords. In fact, there is other batch of petitions.
Now Venugopal should talk to Prabhu. That's the only way out. Yes.
My lord, in item 20, the interim of this.
So their dreams come true. Petitioner's dreams come true through Mr. Swapnil.
Yes. My lords, in fact, the university wants to absorb them, my lords. There are vacant sanction posts.
No, they have a dream, they engage Swapnil. Then the state engages Prabhu. Ravens engages Venugopal. So
right.
Nothing more. What the court has nothing to do.
My lords, maybe on the next date it can be disposed of.
Now, Mr. Prabhu seems to be very upbeat that he will file a counter this time. Yes.
Because the matter is of 2021. 5 years and just elapsed in the meantime.
Of the recent judgments, there has to be some positive response. But there is a communication from the government where government has instructed the university to find out the selection committee who are responsible for this unauthorized appointment. So, my lords, I have to take instruction. I just thought I could.
In fact, my lords, just to bring it to my lord's notice, we have also annexed this in the counter. That order has been stayed by a different coordinate bench, my lords.
Annexure
I mean,
E/4.
the state order
investigating
further.
Yes, my lord.
If annexure E/4 is the counter.
Yes.
Yes.
As far as regulation is concerned, law is well settled. Others not. So I'll take instruction.
And the university
So
also.
if they're otherwise qualified and it was through advertisement,
Yes.
Yes.
it happens at times.
Yes.
And the university also stating that
sound
they are-
band kariyo, Mr. Mathur.
they are-
After notice matter.
after notice.
So if Mr. Roy, listing 100 matters, no problem. But the reasonable is that we have to take up.
I'm
We have to take some matters every day and try to dispose of.
I'm aware of that.
Yes,
Therefore,
yes.
I'm
नहीं डेट ठीक अच्छी डेट ताकू अधिक आपनकर ऑलरेडी तो आगुरु 63 मैटर रहनी जाई 13 तारीख बेलू 63 ऑलरेडी दिया 6 4 87 आज डेट
27th April.
केबे कहले अपन 27 कहले 27 चल
Obviously.
in fact first week of April actually there is no working day.
There's no.
So that is how it has now further piled up. Yes.
My lord, in item 23, the interim order is
interim order as passed earlier shall continue till man.
Copy of the counter is to be served immediately after
Yes,
filing.
yes.
The file code doesn't copy the one.
No, I have changed. I have learned from my esteemed senior. That shall be accepted upon serving copy thereof on the London Council for the
Online file code doesn't online.
online क्षेत्र आमे कर दीजिए सी करना है we are not completely that you file online they are not allowed actually
Online.
yes
Online receipt mandatory. Counter filing is.
because the online receipt mandatory difficult है जो that will add more complication so they have to file the receipt what they will do that while filing online they have to file the receipt of file service of copy.
Yes.
Obviously. Yes, please.
Pardon, my lord. Item 26, I missed, my lord.
Sorry?
Item 26.
26 तो कॉल ही नहीं होते
26 already.
Just.
नहीं 23 टा तापरे मेंशन कर लेता 23 मेंशन कर ले मिस देवराय मिस बबीता पटनायक 23 लिख दे ले एसटी राइट सेकंड मैटर है प्रथम मैटर तो ताको ना नहीं से कहउचंदी एमपी मिस्टर प्रभु जॉनसन नॉट एग्रीइंग सेकंड मैटर तो से कहउचंदी देखिबे वकालतनामा चेक कर दे जदि वकालतनामा थिबो ताल देखिबे नहले ता मिस पटनायक वाज देयर प्रेजेंट she was present. I saw her. And Bobita Kaur Patnaik ka sangar SD rahe. Yes, Mr. Maharana.
My lord, I am sitting on behalf of
Sittikanta
Mishra.
Sittikanta Mishra. तो विषय कौन ऑर्डर लिखले नॉनअवेल काटे लिखो सिट्टिकांत मिश्रा ऑन बिहाफ ऑफ सरोज महाराणा फॉर द पिटिशन
My lord, it's a expert.
सिट्टिकांत yes DP Das sir DP Das for the opposite party matter is listed for the for hearing under the heading so and so the Lorded Counsel for the petitioner sits and has adjournment
My lord,
to address arguments.
it's a expert judgment. It's a
Expert हेले भी देखिए पड़ियो.
My lord, my lord.
So
the here
केबे केबे डेट करछन 27 चाइल
my lord. Shorter date, my lord.
27 डेट हे परियो करंतु जब
Thrice he has been arrested, my lord, for area they Hon'Ble ki he is 74 years.
he has chosen that because Mr. Prabhu takes very good care in food is free, medical facility is free,
And old,
they are adopting that.
Old man of 76 years.
But he will grow further older in custody also. And I find that they maintain good health because of the routine life. Because it is a concern when we find in jails older persons. But since it is food and it is a very regulated life and medicines are provided, that he has chosen that it is. So his determination and law determination, always law determination will prevail. He is determined not to comply the decree. If an old man goes thrice to jail, can it be a ground to not to enforce a decree?
And it has been.
So if you want to make a submission, we are being watched. make a submission legally tenable and legally substanced.
My lord,
Old man going to jail 3 times, how is it relevant in enforcement of a decree?
my lord, say ex parte judgment, my lord.
Whatever, expert it ଆପଣ ସେଟା ସେଟ୍ କରିଥାନ୍ତେ। ଏକ୍ସପର୍ଟ ଆପଣଙ୍କର ଆପଣ appeal କଲା ପରେ appeal କରିଛନ୍ତି ନା କରିନାହାନ୍ତି ଷ୍ଟେପ୍ ନେଇନାହାନ୍ତି?
Appeal କଲେ advocate
ଦେଇଥାନ୍ତେ ନା ଗୋ ମୋଟର ସାର୍ ଦେଇଥାନ୍ତେ?
no, my lord.
Sir, this attitude is spoiling your future, your client's future. The kind of determination he shows, the law has to show that kind of determination. And here it should be actually, instead of now the law will be amended. Instead of civil imprisonment, it will be rigorous imprisonment. Is it that the court has directed for payment? It is the law has directed. The law is made by parliament, not by the court.
The wrong impression it has been done, my lord.
Sir, that for that wrong impression, you have to argue the case there. Now, if I start dictating the order, analyzing the judgment, your entire case will fall flat on its face. Have you checked the evidence on record?
Yeah, no evidence has been taken from this side.
So the
He has been shown as.
So now let us start hearing the matter. If you're ready.
Little short date, I pray.
No short date. No half measures. When the person is 76 and gone thrice for non-compliance of decree. Because you see, nobody is happy to send a person to jail. He is not complying a decree. How it will be enforced?
Unable to comply because
so inability will be a ground not to send someone to jail. Is there any case law? Prepare law, not common sense arguments.
In the judgment,
it is not a drawing room.
In the judgment, it has been shown he is working as executive engineer.
Sir, what you are arguing? What you are arguing? You are arguing that since he is unable to comply with the order, so he should not be sent to jail. Civil imprisonment. Which provision is that? Which case law is that? ଆପଣ ଯେତେବେଳେ ଲ ଶୁଣୁଛନ୍ତି ଆପଣଙ୍କ କ୍ଲାଏଣ୍ଟ ପାଖରୁ ସେତେବେଳେ ଆପଣ ତାକୁ ଏଇଟା ପଚାରିବା କଥା କୋର୍ଟ should not ask you, court should not assist you. My job is not that also. I have to take up the matter and dispose it off. Partly I am also responsible because I am indulgent. I am granting time.
Short date.
Look at the judgment now. This is between the mother and
son. Mother. Paragraph 8.
So the mother being 91 years is not a human being.
Yes, madam.
So human being only for son. Mother is a lesser mortal because she has given birth to a child and has grown old. Mother has to be older than the son has to be older than the mother. So what sort of argument you are advancing? We are being watched, Mr. Misra. A student of law, if he will watch us, then he will be baffled that what sort of argument is being argued. By a son 71, mother is 95. The son says that I am not liable to pay, and the court believed that you are an executive engineer.
No, my lord, they have not.
Anyway,
executive engineer, he is.
Sir, it has already been answered. Because I am indulgent, after it was passed over, it was urgent, I am hearing you. So you argue whatever you want to argue on the next date.
Shorter date.
Shorter date is shortest date has been given. You must understand it. If you are a student of language, I have given you the shortest date. My instruction is that give the shortest date. But I can pick up. I will not take up Mr. Sahoo's matter and your matter only. That cannot be. Yes. Yes, next. ଏବେ ଡେଟ୍ କେବେ କରିଛନ୍ତି କହିଲେ କି ସେ ଛିଡା ହେଇଛି ନା 27 ୱିକରେ ଆସିବେ ୟେସ୍ ନେକ୍ସଟ ଟଙ୍କା ତ ହେଇଗଲା ପ୍ରତି
May I please stand?
Mr. Panchanan Panigrahi for the petitioner, Mr. Satyavadi Mantri for the opposite party.
Yes.
Yes.
The IA which was arising out of a CP that has been disposed of, my lord.
Yes.
In the IA, the learned trial court has directed to hand it over the baby, my lord, that the CP already disposed of, dismissed, madam.
So now you are challenging that.
No, my lord, I'm challenging that IA order, my lord. And then now the CP has been dismissed.
अच्छा original order टा गला Mr. मंत्री को दियो कॉपी टा अरे आपण भी एमटी संग ही सरप्राइज
Already dismissed.
आपण वरुण चक्रवर्ती बड़े बॉलिंग कलेनी तो संजीव चक्रवर्ती is like that but Mr. Panigrahi is saying that the CP has been dismissed. Mr. Mantri is taken aback.
Yes.
So in कौन है जी?
He did not take steps as it appears from the order. He did not take steps in the CP diverse petition, not allowed to dismiss, only to avoid the impugned order in this case. This case is custody of the child has been granted in favor of the opposite party, the mother.
But the CP was not say आपन student हो. CP was not CP is not a subject matter of this case.
No, the IA is subject matter of this case because IA is arising out of the CP.
So then so what was the order here in this case?
Child has been handed over in favor of the people.
Can we look at the order number 3 dated 28/10/24? अच्छी ना ठीक है ऑर्डर टा So order dated 28/24 state that handing over of the custody.
Yes, ma'am.
आपण सीपी टा फाइल करथिले किए?
से हस्बैंड फाइल करथा
Husband failed.
कस्टडी ପାଇଁ चाइल्ड ର चाइल्ड रहउतिले का पाखरे?
No, with me.
Now he is with him. But during the pendency of the divorce case, the husband forcibly took care of the child.
अच्छा. So in that case, then mother has to file a custody petition.
He has filed petition for custody of the child. That is arising out of that.
So CP has been dismissed. गला CP टा वर्तमान आपण हस्बैंड को नहीं गले. CP टा कोन 13 रे फाइल हेतला.
हां
13 गला वर्तमान
previously he has filed another application.
So now both husband and wife will invite Mr. Mantri and Mr. Panigrahi to their home for dinner.
No. But what happened, my lord? He is playing with the wife. But what happened?
आपको पिटिशन फाइल करिया पड़ो. सीपी रे आपनकर 13 फाइल हैला.
आज्ञा
13 रे सेक्शन 27 बदे 27 की 29 अछि जोथरे की कस्टडी फाइल करी हबो.
My lord.
कस्टडी फाइल हैला. वर्तमान सीपी डिसमिस हे गला. ताले आ वर्तमान कस्टडी मु कोन अर्जु. I have understood it correctly, Mr. Mantri.
Knowing fully well, he has previously filed a minor organization. Previously he has filed an application to withdraw the CP. That was rejected.
Rejected by whom?
By the trial court.
ताकू पठिया पड़ो तो जुडिशियल एक्ट मानिया पड़ो. जदि पिटिशनर पिटिशन फाइल करो विड्रॉल पे ताले जो ट्रायल जज कहबे जे तुम करि परिबोनी.
नहीं काय only
अछि.
on the ground that since the IA is pending for custody of the child, you are avoiding to
कस्टडी टा फाइल हबो एथिरे. कस्टडी टा अन्य प्रोविजन अछि फाइल करिया पे. हिंदू माइनॉरिटी गाइडेंसिप एक्ट रे कस्टडी फाइल हबो. हिंदू थिला बोली फाइल हला. आपण ता कहबे जे जेतु सेटा आपण कोन एटा तो सिलेबस हे गला ताले. सिलेबस रे जोटा सुप्रीम कोर्ट that is a PIL, diffuse social rights.
Kindly see the conduct of the husband. What can I see? He did not take
Sir,
steps in
every conduct is not legally challenged. And the wife is not remediless.
That's true, but
you see, Mr. Mantri, think the larger picture. If the wife is agreeable to stay with the husband or the husband is agreeable to stay with the wife, see,
no, that is not agreeable. That is the whole. What is the matter?
I mean, don't be that skeptical.
No, man, I am.
Once 13 has been dismissed, the sex, ଆପଣଙ୍କର ସେ provision ଟା ଅଛି ଏଥିରେ ହିନ୍ଦୁ ମ୍ୟାରେଜ ଆକ୍ଟ ରେ ଅଛି. Chabis, custody of children.
Yeah.
So 26 arising out of a section 13 application, after the 13 application has been dismissed, who will not survive. But that doesn't mean that Minority Guardianship Act, the wife cannot file a. And suppose now, Mr. Mantri, if I accept your argument, and I mean the proposition of law propounded by the learned trial court, section 26 is the only petition can be filed.
No, once this 26 application, they
kindly ଆପଣ ବା ବହି ଆଣିଛନ୍ତି?
ବହି ଆଣିନି.
ଆଉ ତ ପଇସା ମୁଁ ବହି ଦିଅନ୍ତୁ. ହିନ୍ଦୁ ମ୍ୟାରେଜ ଆକ୍ଟ ଅଛି ଭଲ
ପାଇଲିନି.
26 ଦେଖନ୍ତୁ. 26
custody any proceeding under this act.
ସେତିକି ଆମ ପାଇଁ relevant for our discussion in any proceeding under this act.
Yes, ma'am.
That much.
Yes, ma'am.
So here only that is how ଆପଣ ଯଦି once any proceeding ମାନେ 13 proceeding or 9 proceeding.
Yes.
Can be 9 also.
Yes.
Or 11, 12 also. 11, 12, 9, actually child custody is rare.
No.
So in case of a 13 or 9 proceeding, so 26 can be filed. Now if I accept your argument and the proposition of the learned family judge, then I have to, direct that 26 is the only provision. 26 is not the only provision. Minority guardianship ଅଛି ଯୋଉଥିରେ ଅଛି କି the welfare of the child ସେଟା. That there can be any other provision. But what you are saying is correct. Adoption and maintenance भी ଅଛି ସେଥିରେ ବି custody ପାଇଁ ଅଛି. ସେ ଯୋଉଟା ସେ କରିବା କଥା କରିବେ. What you are saying will be correct. That as a matter of legal strategy, he defaulted and the suit is dismissed.
Adoption and maintenance ରେ custody of child ତ ନାହିଁ.
Custody ଅଛି ସବୁଠି ଅଛି. ଚକ୍ରବର୍ତ୍ତୀ କୋଉଥିରେ ଅଛି ସେଟା? Minority guardianship. Guardianship ଅଛି. ଠିକ ଅଛି ମାନେ ସେ ଯୋଉଟା ବି ହଉ it is there. Custody ଜଣେ mother or father can seek custody of child.
And by this process, my lord, he is trying to, what happened, first of all, he filed the application of divorce. In that case, the court.
There the problem, Mr. Raj, I have already explained to Mr. Mantri, if the husband doesn't want to prosecute a 13 application, how the court will interfere?
No, only to avoid this order.
No, sir, I'm answering. You are repeating that I've heard this order, you have said 10 times. What is my answer to you? Have I not answered?
Yes, my answer.
So what is the answer?
No,
since you moved the application under section 26, it has to go. Court cannot retain. Court cannot retain itself or detain itself after the 13 is dismissed. Still will adjudicate 26. And the language of 26 is very clear. In any proceeding under this act, very clear.
मैं मंडे आसु देखिए मुझे चेक करते कहते
आप चेक करिवे आपण जेतु एटा प्रेशराइज करले आपण गला थर ऑब्जेक्ट करले पानी रे कहले जे ताऊ सेठी माने कर दियो नॉन अपियरेंस को डिसमिस कर दियो आई रिमेंबर जो अर्जनमेंट नोतले एंट्री मॉडल अछि अर्जनमेंट ले आपण बहुत ऑब्जेक्ट करले देखले आ दोस्त मंत्री को पारी होनी but obviously 26 is not the only answer. Custody पे अन्य provision अच्छी.
And will be harassed na? The wife will be harassed like this.
13 dismissal is now she the relationship improves.
And that's true.
So that is how I said you have to look at the much bigger picture. Maybe the child's issue is the persuasive factor for both the parents to live together. Let us be hopeful.
No, that is the law. In the law, that is the right. But fact,
certified copy ଟା xerox କରିଦେବେ ଦିଟା.
the fact is different.
ଆପଣଙ୍କର କପି ଅଛି? ଦିଅନ୍ତୁ ଗୋଟେ memo ଦିଅନ୍ତୁ ସାର୍.
Yes, madam.
But the fact is different.
No. ସେ ଆପଣଙ୍କ ଷ୍ଟୁଡେଣ୍ଟ ସେ ଆପଣ ତାଙ୍କୁ କହିଛନ୍ତି ଏମିତି କରିହେବ ବୋଲି. ଯଦି ବେଶୀ ଅସୁବିଧା ହେଉଛି ଆଇରେ ମେନ୍ କେସ୍ ଡିସମିସ୍ ହେଇଯାଉ. ପରେ ରେଷ୍ଟୋରେସନ ଫାଇଲ କରିବ. ଆଜି ହେଇପାରେ. ସେଟା ମୁଁ ଆଡ୍ କରିଦେଲି. That twist I am adding.
Whatever during the penance of the CP, in spite of the order of the court, trial court, he did not come forward for conciliation 4 to 5 times.
They are a little difficult. Nobody is, Mr. Mantri, nobody is listening to lawyer as far as matrimonial cases are concerned.
That's true. But
when somebody comes with a brief to you, if you advise, he will go away. You don't have a choice. ଆପଣ ଠିକ କଥା କହିବେ, he will go away. He will engage Mr. Paningrai. Same thing to Mr. Paningrai also. If you advises correctly that this is the provision of law, he will not listen. Even to this extent, upon the Sunile, how the facts are stranger than fiction. A son of 72 years of age, mother 95. 72 years of age, his son has gone thrice for civil imprisonment. Non-compliance of decree 125(4), mother and father. Tabi hochi. One day, one of my secretary, maybe the other, she said that today the parents have to come to court for getting it to be maintained. That is the reflection on our society. But as far as law is concerned, can I help the son or the old mother? That is also not there. Appearance actually. So, Lord Counsel for the parties who have had at length. Is submitted by the Lord Counsel for the petitioner. At length, the petition, the writ application has been filed. By the husband in the marriage, father of the minor child. They have only one daughter, Devanshi. Okay. And the child is at about
9 years now.
10 years old. Anyway, is it about 9 years? Stop. The father and daughter both have the petitioners. I want them to copy the
Yes, ma'am.
patient.
Yes.
Xerox copy ଅଛି?
Yes, ଅଛି.
ଏଟା ଫେରେଇ Xerox copy ଟା ନେଇ ଆସ। ତାକୁ attested କରିଦେବେ। କଣ ଲେଖିଲେ? Petitioners. The daughter being minor is represented through the father. Stop. You take your seat. Mr. Mantri, kindly be seated. Minor is represented through the father. The petitioners, by filing the writ application, challenges the order dated 27.02.2024, passed by the Lord, challenge, plural, both. Challenge the order dated 27.02.2024, passed by the Lord Senior Civil Judge Anandapur. In IA number 62 of 02, 62/02 of 2023. Be clear. Stop. The IA before the Lord Civil Judge arises out of the CP number 13 of 2023. Para. The said CP was filed by the mother, Mr.
No, husband.
Husband. The CP was filed by the husband in the marriage under section 13 of the Hindu Marriage Act. (13 into bracket 1 into bracket small Roman I dash small a bracket closed of Hindu Marriage Act, 1955. For dissolution of the marriage solemnized between the parties to the CP on 28/4/2015. Para. The IA was filed under section 26 of the Hindu Marriage Act. IA number 2 of 2023, arising out of the CP, was filed under section 26 of the Hindu Marriage Act by the wife, mother of the minor girl child. Stop. Pursuant to the notice issued by the coordinate bench by order dated 02.08.2024, the opposite party wife dash mother of the child has appeared The matter was referred to mediation by order dated 14/11/2024. Para. Mediation किसी नहीं होता. The mediation has not yielded any result. Stop. Today, the matter being in the list is taken up for hearing. Matter being in the list under the heading for admission. Taken up for hearing. The learned counsel for the petitioner produces certified copy of the order dated 13/2/2026 passed by the learned civil judge senior division Anandapur, which states thus. Quote kar do, scan kar do. The learned counsel for the petitioner also files memo including colored photocopy of the said certified copy of order dated 13/2/2026. The certified copy is returned to the learned counsel, retaining the colored photocopy of the order. Photocopy of the order is also handed over to the learned counsel for the opposite party. Stop. In view of the dismissal of the CP, the IA filed therein before the learned civil judge senior division under section 26 of the Hindu Marriage Act would also no more survive. Stop. In view of the above, nothing survives for adjudication in the present proceeding before this court. Stop. It is submitted by the learned counsel, Mr. Mantri, for the learned counsel for the opposite party, that the custody of the child being with the petitioner father, the efforts of the mother seeking custody under section 26 of the Hindu Marriage Act has been frustrated. Para. In response to the said submissions, it can be observed that the mother of the child, if so advised, shall have all her remedy open, seeking custody of the minor girl child. The petition is disposed of. এটা লাগিব মেমো ঢের লগেই কি Sir, you went to purchase chocolate, sir?
Yes, sir. Sir, ଆଜି ମାନେ ଗୋଟେ ବିରାଟ ବଡ ଆଲୋଚନା ଚାଲିଥିଲା ଲଞ୍ଚ ଆୱାରରେ ସେ ଟେନସନଟା ସାର୍ ସେଇଥିପାଇଁ ମାସର ଗୋଟିଏ ଶନିବାର କୋର୍ଟ ହବ ଏବଂ ଦ୍ୟାଟ୍ ଟୁ ଅଲ୍ କ୍ରିମିନାଲ ଓଲ୍ଡ ମ୍ୟାଟର୍ସ ୱିଲ୍ ଟେକେନ୍ ଅପ୍ ବାଇ ଦି
sir ଗ୍ୟାସ୍ ଆଗ ଆସୁ ଆପଣଙ୍କର 12ଟା ଜାହାଜରୁ ଗୋଟିଏ 2ଟା ଜାହାଜ ଆସିଛି ସେ ଫେରେ ପୁରା କଣ୍ଟ୍ରି ପାଇଁ ଗ୍ୟାସ୍ ଆସୁ ଖାଇବାକୁ ମିଳୁ ସାର୍ ଦ୍ୟାଟ୍ ଆର୍ ବିଗର ଇସ୍ୟୁ ସାର୍ ମୁଁ ହେଲେ ଆପଣ ସେଇଟା କହିବି ଆପଣ କହୁଛନ୍ତି ଗୋଟେ ଶନିବାର ଦିନ କଣ ହବ
ଏଇ ଦେଶରେ ଯୋଉ ହେଲା ସେଥିପାଇଁ ଟିକେ ଟେନସନ ସୁପିଲା ଓକିଲମାନେ ରହିଛି
sir why they think sir when we are having chocolates you should have given ଆପଣ ଦେଲେନି ଅଦର ସାଇଡ୍ ବି ଦେଇନାହାନ୍ତି
ଅଶୋକ ସାର୍ ବର୍ତ୍ତମାନ
ଆଇଟମ ସାର୍
ସାର୍ 19
ପଛରୁ ରିଜନରେ ଫାଇଲ କରିନାହାନ୍ତି ତ
ସାର୍ ସେଇଥିପାଇଁ ମୁଁ ସାର୍ ଟିକେ କହିବାକୁ
ଠିକ ଅଛି
ସେ ରହୁଛନ୍ତି
ଠିକ ଅଛି ମିଷ୍ଟର 19 days ଅର୍ଡରଟା ସେଟ୍ ଖାଲି ଏୟା ଚେଞ୍ଜ ହବ ଯେ the Lord Counsel for the petitioner seeks further time to ସେଟା ଅଛି already ଆପଣ ସମୟ ଦିଆଯାଇଛି I remember the chocolates but you must have something for persons who are having diabetes
ନା ସାର୍ ଡାଇବେଟିସ୍ ଯୋଉ ହଉଛି
ହଁ ସେଟା ଆପଣ କଣ
କହୁଛି
ଆଜ୍ଞା ଆପଣ ତ ଯାହାର ଡାଇବେଟିସ୍ 11 ବର୍ଷ 12 ବର୍ଷ ହେଇଗଲାଣି ଆପଣ ତାକୁ କିଟକାଟ ଦଉଛନ୍ତି
ସାର୍
କିଟକାଟ ଲେଖା ହେଇଛି ସୁଗାର ଫ୍ରି ଆପଣ ମତେ ଲାଷ୍ଟ କଣ ଦେଇଥିଲେ ଆପଣ କିଟକାଟ 2ଟା ଦେଇଥିଲେ
ସାର୍ ଖେଳ ଆପଣ ସାର୍ କଣ ଦେଖାଉଛନ୍ତି ବର୍ଷର ଥରେ
you must understand the medical history of the person you are giving
ଦେଖି ସାର୍ ଡକ୍ଟର ମାନେ କହୁଛନ୍ତି ଯୋଉମାନଙ୍କର ଡାଇବେଟିସ୍ ରହୁଛି ପାଖରେ ଚକୋଲେଟ୍ ରଖନ୍ତୁ
ସେଇଟା ଅଲଗା ଜିନିଷ ସେଇଟା ହାଇପୋଗ୍ଲାଇସିମିଆ
ସାର୍
ସେଇଟା ହେଲେ ସିନା
ଆଉ ବର୍ଷର ସାର୍ ଥରେ ଚକୋଲେଟ୍ ଖାଇବା କାରଣ ବାହାଘର କାମ କାର୍ଯ୍ୟ କଲେ ସାର୍ ମିଠା କ୍ଷୀରି ଖାଇବା ଟିକେ ଭଲ ଲାଗେ
ସୁଭାଷ Mr. Ratha was running actually. He was looking loss of sugar. ତାଙ୍କୁ ଦବାର ଥିଲା.
Sir.
He was breathing heavily and I thought that he has not had chocolates. Mr. Ratha came. He usually is not absent. You are present. But today he came, you are not there.
Mr.
Dilip Rai, Mr. Subhash Chandra. ଅର୍ଡରଟା ଯାହା ଅଛି ସେ ଟିକେ ମଡିଫାଇ ହେଇଥିବ. ନନ୍ ଅଫେନ୍ସ ଜାଗାରେ କହିବେ ମିଷ୍ଟର ଦିଲ୍ଲୀପ କୁ ପାତ୍ର. ଦିଲ୍ଲୀପ ରାୟ. But best part is that now I think whenever you take a plea that I went to get chocolates, so that will be a ground for adjournment.
Nice.
Non-appearance, sorry, condone non-appearance. I'm so sorry. That will be a ground for condoning non-appearance. Yes.
Nice. Sir, with affection, love, sir, with cooperation.
And you have to take care of health. Everyone should take care of health. बाहर रे बहुत मेंबर दुख लगे younger member my contemporaries they passed away because perhaps they were not that careful. Yes, next.
Item 29.
Mr. Rakesh Bera for the petitioner. So Parija, yes, transfer ହେଇଯିବ ଆପଣ ରାଜି ହୁଅନ୍ତୁ ଗୋଟେ ଜାଗାରେ ରାଜି transfer କରିଦିଅନ୍ତୁ both of you agree both Mr. Bera and Mr. Parija.
The reason we are seeking transfer to Bhadrak is that several other proceedings that are also pending at Bhadrak. So by virtue of the judgment of this Hon'Ble Court on 3 other cases, all the cases were transferred to Bhadrak. In fact, now also a DV proceeding is pending before Bhadrak.
One is Bhadrak, one is the present place of what the maintenance cases. Mr. Parija, I think what he's saying is that in similar fact circumstances,
yes.
Already this court has directed transfer. That I think that is his contention.
Yes. But now the present situation, 2 of the cases of the Bhadrak that has already been disposed of. One case is pending DP and another case is Nilagiri also pending where the husband is contesting, that is a criminal case. He is also appearing there. Now the DP case is Bhadrak. One case is Bhadrak, one case is Nilagiri.
And this is a transfer short for from Nilagiri to Bhadrak.
Nilagiri to Bhadrak.
তাহলে আর কিছু দিন আর্জন হয়ে গেলে সেটা ডিসপোজ অফ ହେଇଯିବ সରିଯିବ আর্জন খালি ହେଇଯାଉ ତାହେଲେ ନା ଆଜି ডিসপোজ କରିଦେବା ନୀଳଗିରି କେସ୍ ନୀଳଗିରି ଭଦ୍ରକ କେସ୍ ଭଦ୍ରକ
See, जो 4th case टा क्वेश्चन तार रिगार्डिंग I don't have instructions. Will give me, Lordship will give.
No, he, obviously he has received instruction, how he will know.
No, he appeared there, got the stay order. Now he contested that the LMC is
Disposed of. Whatever way, dismissed or allowed, but
Lordship, I am not receiving problem. I am not receiving any maintenance from anywhere. Everywhere is.
no, you are not receiving because of stay order of this court.
No, one is 120.
You should execute. Because execution part, though Supreme Court has directed very stringently, still execution is not effective. Especially in matrimonial matters, is not getting executed.
In fact,
because this court cannot execute. You have to pursue relentlessly the execution there.
in fact, the CP case has been, the divorce proceeding have been allowed. They have challenged that in Mata, and we have already deposited the 7 lakhs permanent alimony that was awarded by the.
Mr. Parija, that this plea is not available. After the CP, he has you should accept the permanent alimony if
I am not the counsel, but the matter, 2 matters are filed for this.
So, Mr. Parija, not that. You may not be the counsel, I realize. Otherwise, you would have known that. Kindly consider this. In a matter, you are contesting. Suppose the divorce is granted and you are contesting. Then, if you are contesting, then your stand is you are registering the divorce or not registering the divorce.
The Section 9 divorce, both are disposed of analogously.
Correct. Section 9 is by you, you are for the wife.
That was discussed.
So whether you want divorce or you want a restitution.
Restitution.
So then you cannot accept the permanent alimony.
No, that I have not.
So now since he has deposited permanent alimony, so then now it is complicated.
It is, I don't know what is.
Because he has a decree in his favor.
I don't know what is the matter court has been proceeded.
Simply let us adjourn it.
Right.
The Rakesh Behra, appearance likely. The learned counsel for the parties were heard at some length. It is submitted that the petitions which were pending before the Lord Judge Family Court Bhadrak, out of the petitions, it is submitted that out of the petitions which were pending before the Lord Judge Family Court Bhadrak, 2 has been disposed of already. 1 matter is pending under the provisions of DV Act.
Section
the
12.
provisions of Section 12 of the what is that DV Protection of Women so and so DV Act stuff. The other matter, that is a 9 application or 13 application. Nivagirita?
Nilagirita is a criminal offense. It's a 498 offense, a city case number I've given. It's a criminal case.
The criminal application, the criminal trial, that's a trial. The criminal trial is pending before the Court of Jurisdiction at Nilagiri. Paras. It is further brought to the notice of the court that the CP filed by key file kortele wife na husband. The CP filed by the husband seeking dissolution of marriage has been allowed, granting a permanent alimony of ₹7 lakhs. It is submitted by the learned counsel for the petitioner as husband in the marriage that the decree has been satisfied by depositing the amount before the learned court. Stop. It is submitted by Mr. Parija that as per his instructions, MATA has been filed.
2 MATs.
2 MATs have been filed by the opposite party wife, wherein he is not the counsel. Stop. The learned counsel have adjournment to obtain up-to-date instructions. List in the week commencing. Kodiyachari. So, Parija, it is antithesis. You allege 498A and you want to sustain the marriage.
So,
must understand, when you are making allegations of 498A, how do you sustain the marriage? It's completely you are, diametrical opposite stand you are taking.
That is illegal.
You should not have filed those cases. And the way things are progressing, most likely 498A will not be proved. Anyway, this is so that is how I'm asking, I'm suggesting that you should talk to your client and she must understand what she is doing. Valuable time of her life is being spent like this. one after another litigation. Litigation at 3 places now, Nilagiri, Bhadrak and Cuttack. And I mean, I don't know, even you do not know, as you say, that how many cases where it is pending. Can I call it? Date call it? 20 child. 20 child rakho, era 27 child rakho. Yes, Mr. Sahoo. Mr. Jali sought for adjournment or something.
Your Lordship, adjournment.
Upon husband,
Yes.
we are so happy. Stay here, upon don't paisa.
I don't paisa.
Paisa don't.
Thank you.
Yes, sir.
Allowed 2 weeks time for filing the.
Your name, sir? Itre
PK Naik.
revision ne counter कौन file करिवे? এটা कोन read application. କରୁଛନ୍ତି ଠିକ ଅଛି, but I cannot take note of everything. There is a limitation as far as revision is concerned. I have to concentrate on the pleadings and the plaint and written statement before the trial court. Jyotirmoy Sahoo for the today adjournment, why Mr. Patnaik is not there? He has to take adjournment. You are arguing counsel, he is adjourning counsel. Mr. Jyotirmoy Sahoo for the petitioner. Mr. Naik, Mr. PK Naik. PK Naik for the opposite party. The matter is listed for hearing under the heading so and so, so and so. Learned counsel for the opposite party seeks adjournment to advance arguments. Accordingly, the matter shall be listed in the week commencing 27/4/2024. Yes.
Interim order to court.
Interim order as passed earlier shall. ଆପଣ ତ ଏତେ ଭଲ ହବା କଥା ନୁହଁ, ଇଣ୍ଟରିମ୍ ଅର୍ଡର ଥାଇକି ବି ଆପଣ ଦଉଛନ୍ତି।
Subject to ଅଛି ପରା।
Subject to. Interim order as passed earlier shall continue till the next date of hearing.
Obliged.
Yes, please. Next.
31.
Mr. Gopinath, Mr. Senior Advocate, along with Ms. P.P. Mahanti.
Mr. Parida.
Mr. Parida. Full name, sir?
Siladitya Parida.
Siladitya Parida. For the petitioner.
Petitioner in the first case, OP in the second case.
Yes, Miss. You're Miss Jajodia.
Senapati, Your Lordship.
I'm so sorry. Saraswati Senapati.
Shweta Senapati.
Shweta Senapati. Okay. Miss Shweta Senapati for the opposite party. Yes, Miss Senapati, what do you want?
Your Lordship, we have filed this particular petition for the enhancement of the maintenance that we have received, Your Lordship. And on the previous occasion, Your Lordship was of the opinion that both the parties should sit and come to a middle ground if there is any.
That's the best way. I mean, instead of spending time in again and again arguing and contesting without achieving almost nothing, the result will be almost nothing.
In fact, I was talking to my friend last evening. I have intimated to the trial court lawyer.
Yes.
He is in the process, but he says he is in the process of negotiation.
Correct.
But my friend intimated that her client denied that any move is initiated or not. So Your Lordship may grant us a small adjournment so that it can be settled out. If settled out, otherwise we shall argue on it.
Mr. Mishra, you are challenging the entire
yes.
The RPFM 192 of 2025. The application has been filed by the husband in the marriage challenging the order dated 27/2/2024 by the Learned Senior Civil Judge Anandapur. What case? I'm sorry, I have opened another case.
RPFM 192/20.
Sorry, I have opened some other.
Cross.
RPFM 192 of 2025. The petitioner husband in the matter is listed for hearing under the heading for admission. Please be seated. I'll take some time. I'll adjourn about 4 weeks.
Yes.
Yes. Our learned senior advocate for the petitioner and Ms. Shweta Senapati for the opposite party. The petitioner husband in the marriage is before this court challenging, seeking revision of the judgment dated 18.04.2025 passed by the Lord Family Judge Hon'Ble in criminal proceeding number 03 of 2022. Stop. The said the criminal proceeding, the said criminal proceeding was initiated at the instance of the wife in the marriage under the provisions of section 125 of CRPC, seeking monthly maintenance at the rate of rupees 35,000. Section 125 actually. The bracket since repealed and substituted by the perimeter provisions contained in DNSS 2023. The petition was favored. However, granting monthly maintenance at the rate of rupees 20,000 with effect from the date of application, that is 05.01.2022. The connected RPFM 376 of 2025 has been filed by the wife seeking enhancement of the maintenance directed by the learned Judge Family Court Hon'Ble in the above CP. Para. It is observed that the parties can work out a amicable settlement acceptable to both to arrive at a figure, arrive at an amount towards monthly maintenance or any other similar amicable settlement. The learned counsel for the parties are requested to make such an stop. The matter shall be listed in the week commencing 4/5/2026. Second matter. RPFM 376 of 2025. In view of the order passed in the connected RPFM, so and so, the matter shall be listed in the week commencing 4/5/2026 along with the said case. Yes, next.
Item 32.
Yes, please.
32, the sole question is,
yes, please.
Maintenance to be granted from which date? From the date of application or from the order?
Yes.
In spite of Rajnish Neha, the learned Judge Family Court has granted maintenance from the date of order.
Any reason?
No reason has been shown. No reason has been.
Yes. Sir, you are along with Mr. Chakraborty.
No,
he is with me. He is with me.
He's for.
My lord, one short adjournment.
No, the problem. No, you. But only thing is that you have to address me after reading our Rajnish versus Neha.
Actually,
You see, this is directly in conflict. Something is in directly conflict with the Supreme Court direction. I don't have a choice.
no, sir.
The High Court doesn't have a choice.
Today we have filed the written objection. So
Written objection I cannot entertain.
Not necessary.
And if I start entertaining, it is contrary to Swami Mahakari.
my senior is not there, so
Okay.
that's why I'm.
So when do you want?
One short adjournment.
32, Mr. Sanjeev Chakraborty for the petitioner. What's your name, madam?
Anvesha Priyadarshini.
Ms. Anisha Priyadarshini for the opposite party. The learned counsel, Ms. Priyadarshini, in absence of for leader, 6 for adjournment. Para. it is submitted by the learned counsel for the petitioner that the matter that falls for adjudication before this court in the revision is within a narrow compass. Stop. The short point is whether the maintenance directed to be paid by the learned judge so and so forth shall be from the date of the application, of date of filing of application, or any other date. Stop. It is submitted that the proposition of law has been authoritatively settled by the Honorable Supreme Court in Rajneesh versus Nehal. Citation दे देना. Stop. As sought for, the learned counsel for the opposite party has adjournment. Stop. The matter shall be listed for orders in the week commencing.
Odisha.
नहीं कोड़े चार
बहुत गुड़ा रह गलानी की सकाळु सुनजु खाली
सकाळु खाली कोड़े चार चले
जालसनी बहुत
Chance for argument.
आज्ञा आज्ञा
So one chance for argument.
आज्ञा केबे आपण तो से आपण कोड़े चार नहीं गलेनी बर्तमान सी व्यस्त हो गलेनी
ना मु व्यस्त में काल केस
आपनकर केस ऑर्डर से आपण 6-4 आसु हला इन द वीक कमेंसिंग 6-4 Yes.
34.
33 टा से बोधे देचंती अच्छा 34 Mr. SSK Nayak for the petitioner, Mr. Jyotirmay Sahu अपन तो नाम
For Pradeep Behra, my lord. On behalf of
Jyotirmay Sahu Pradipta Kumar Behra.
Yes, ma'am.
पशायत थिले पर आइठी ना कौन पशायत पढ़ेले असला Mr. Pradipta Kumar Behra for the opposite party. Yes, yes sir.
My lord. Your my lord.
Mr. Sahu कौन कहउछन adjournment
No, no, adjournment.
Yes,
Let
yes.
them transfer the matter, my lord, and the opposite party is permitted to appear before virtual mail.
That application you have to file.
Yes, yes.
Okay. So SSK Nayak for the petitioner, Mr. Jyotirmay Sahu on behalf of Pradipta Kumar Behra for the opposite party. Both of you please be seated. I'll dictate the order. I'll take some time, at least 5 minutes it will take, or maybe more. The petitioner husband, the petitioner wife in the marriage is before this court. Seeking transfer of the civil proceeding number 1271/2024 from the court of learned judge family, the learned family judge dash Roman 2 capital, comma Bhubaneswar to the learned judge family court Bhadrak. Alright. The CP has been initiated one two seven one. Petition copy टा केते annexer? है नहीं?
Pardon, my lord.
What is the annexer number of petition? Copy टा
Petition is annexer 6, my lord.
6 तो मिसुनी?
6 page 33.
हाँ, yes. Correctly? It has been initiated under the provisions, invoking the provisions of Section 27 of the Special Marriage Act, 1954. Seeking a declaratory relief. Seeking age or declaratory relief काटी दियंतु. With a prayer for grant of decree of divorce. Alright. To support the claim of support the prayer seeking transfer, it is submitted that application filed by the petitioner under section under section 12 of the Protection of Women so and so Act, that is DV Miss Case number 255/2024, is pending before the learned SDJM Bhadrak. It is further submitted that that C capital R capital P capital number 348/2024, filed by the petitioner wife in the marriage under section 144 of CRPC, under section 144 of BNSS 2023, is pending before the learned judge, Family Court, Bhadrak. Alright. It is further submitted that certain cases under the provisions of certain other cases under the provisions of the BNSS IPC code है BNS. Provisions of BNS 2023 is also pending before different court of the different courts at Bhadrak. Stop. It is submitted that the petitioner stays at Bhadrak with her parents after her marriage has run into rough weather. Staying with her parents? Okay, stop. Yes. Opposing the prayer for transfer of the petition, it is submitted by the learned counsel for the counsel Mr. Sahoo, appearing on behalf of the learned counsel for the petitioner, that Section 9 read with Section 9 of the CPC, Civil Procedure Code of Civil Procedure, read with Section 19 of the Hindu Marriage Act 1955, would lead to a irresistible conclusion that the court at Bhubaneswar has jurisdiction. Stop. It is further submitted that the provisions of Section 20, the provisions contained in Section 24 of the Civil Procedure Code makes it clear that the court has to consider within double quotation marks, convenience of parties while considering transfer application. Stop. Para. In considered opinion of this court, the contentions raised by Mr. Sahoo, learned counsel for the appearing for the opposite party, are correct. The court cannot, the constitutional court cannot look for convenience of one of the parties. Stop. However, taking a sympathetic view, it is directed that the CP number 1271 of 2024 from the pending before the Learned Judge Family Court dash English 2 Bhubaneswar shall be transferred to the Court of Learned Judge Family Court Bhadrak at the stage which it is now. Stop. The petitioner wife has to accept the consequence that now the petition becomes registered as a petition of the year 2026 and have its own priority before the new court. Stop. The parties are directed to cooperate before the Learned Judge Family Court Bhadrak for effective hearing and completion of the proceeding. Stop. Para. It is submitted by the Learned Counsel, Mr. Sahoo, appearing for the opposite party, that the opposite party may be allowed the provision of, allowed the benefit of ICT, various ICT initiatives, ICT facility, various ICT facility for appearing before the Learned Judge Family Court Bhadrak. Para. Accordingly, it is further directed the parties to the proceeding, if so advised, may approach the Learned Judge Family Court for extending them the available ICT facility. Stop. Upon such application being made, the same shall be considered by the Learned Judge Family Court Bhadrak, and appropriate orders shall be passed in accordance with law. Stop. This court also puts on this court, before parting with the case, also puts on record its appreciation for the efforts made by the Learned Counsel for the parties in arriving at in disposal of the matter which is pending since 2024. Since 2025, the further proceeding in the CP, which is of 2024, having been stalled. Stop. Yes. Yes, disposed of. Next. Other matters in paucity of time.
Pardon, item 29, interim order may be continued.
29. 29 interim order to continuous. Password.
Password item 20, my lord.
Yes.
Kindly take it on 25th, my lord.
25th
next week, my lord.
Next week କରିହେବନି. Already both today matter for 2020 तक केबे କରିପାରିବେ?
March last month 30.
We commencing 6/4.
6/4.
Yes. Rest of the matters kindly take dates Any mention, Mr. Yes. You are mentioning any matter?
Item 37, we both are present.
Yes.
Your lawsuit on dated 3/12/2025 directed the district legal service authority. He has submitted a report and
have you gone through that report?
No, sir, no, I didn't. I don't have the. And there are some mistake in the petition. They need to amend that.
You just bring it to the notice of your laureate colleague. You take a date out of this. Mediation has not possible. Mediation has failed.
Sir. Any convenient day. Yes. Any
date कर दो.
We counsel code, sir.
Deeply obliged.
Mrs. Das, your matter. You are making a mention. Okay. No. Today, since there is paucity of time, so already intervened. 36 date कर दियो तो. Tomorrow होगा. It has to be spread over.
We counsel code, sir.
अगर 6/4 87 already है. 13/4 week. Yes.